and you're going to be subject to random drug testing. Anything else?
Nope, completely understand, Your Honor.
All right, good luck to you, Mr. Slayton.
Thank you, sir. Thank you, Your Honor.
Your Honor, there was a reimbursement on that of $250 to you. I'm not sure if you said that.
Yeah, go ahead and put that on.
Thank you.
Is that just a fine, Your Honor, essentially, or?
It's a reimbursement for the cost of drug testing.
Oh, okay. Okay.
All right, that's all.
Are you?
At this time.
Your Honor, I have not seen my officer, Mr. Boot, and I have both checked both of the witness meeting areas and the hallways. The city would be making motions.
Motion is granted.
They're all set.
Thank you. City of Lansing versus Don Ye Logan, 25-02714. Have we seen Don Ye Logan?
Your Honor, I'm waiving his appearance. There was a civil infraction offer made last week that he has given me permission to accept.
Community service, so we're not doing that anymore?
Your Honor, that was submitted to the city attorney's office, which is why the civil infraction offer was made.
That's correct.
This must have been Judge Paul. I'm trying to read it anyway. Okay, so looks like it's in October, he was unhoused, living in his car.
Yes, Your Honor.
Is that still the case?
Your Honor, he is working now. I believe he has gained temporary housing. He's getting on his feet. Part of the reason he was so eager to accept the opportunity he was given through the community service was he started orientation this week.
Okay, what is the civil version?
It was a breach of peace civil infraction. Your Honor.
It's fine, $75.
Thank you, Your Honor. He advised you pay probably today, but definitely by the end of the week.
Thank you.
Thank you, Your Honor. When I get Mr. Bridges in a breakout room.
Representative Mr. Delzon.
Your Honor, I didn't hear his name called.
Anthony Delzon.
Yeah, present.
It says Warren. No, it's Warren Sutton. Okay, we're waiting, we'll wait for your attorney. Who do you have, Ms. Strong?
I have Chastity Morse.
City of Lansing versus Chastity Lynn Morse, 23-02016, appear please.
Elizabeth Perkins on behalf of the city of Lansing.
Assistant Public Defender Justin Strong on behalf of Ms. Chastity Morrison, who is standing to my right.
Chastity Morse has a hearing imposed, scheduled today for final pretrial. Was there an offer?
Yes, there is, Your Honor.
Who's the offer?
It's for breach of peace.
Just for the record, you tell the offer for that one.
Yes, sir.
Thank you. And she said accepting the offer?
Yes, Your Honor.
That's correct? Is that a yes?
Yeah.
Okay. Your fine is $75. Can you pay today?
No, I cannot. I owe like 700 and something rent. Right now I'm struggling. I'm on fixed income, I'm on SSI, and I'm on assistance. I'm sorry, I just got through crying. Like, I think about my daughter that I had to bury the murder. That's why this situation occurred because I was drunk and went in the right line and my daughter had got murdered.
I'm sorry to hear that. This is recent?
No, it's from years ago.
It was in June of 2022.
No, my daughter, yeah, well, I'm talking about,
This incident?
yeah, it was after my daughter died.
This incident was from New Year's of 23, I believe, from.
Okay, and it was related to the loss of your daughter?
Me drinking and me being in that situation, yes. My mind wasn't right at that time.
And you had interaction with the police or something?
I don't even remember. I guess they were questioning me about, I have no idea. I don't even remember.
Questioning you about the incident of your daughter or?
No,
Oh,
I was drunk at that time and me being drunk led to,
got it.
only way I could cope with it at the time was drink. I don't drink no more though.
I'm glad to see that you're not, or hear that you're not drinking anymore. I wouldn't say that's the only way that you could cope. That was just the way that you were coping at that time. And everybody grieves differently.
And I'm not gonna lie, I wasn't too fond of the police because being around the police because the police let my daughter bleed for 7 hours in Detroit, bleed to death. So wasn't too fond about being around the police after that.
Hopefully you're dealing with the trauma in a healthier way and not through alcohol. Your fine of $75, I'll waive it and close the file and you're all set.
Thank you.
Thank you.
Thank you.
Mr. Perkins is also ready.
Code enforcement here for matter. Ray Garcia. I'm sorry, I'm not sure what matter he was. He was there, Ray Garcia? Me neither. Do we know Ray? Do we know Ray Garcia? Ray Garcia? It's Gino.
I'm Garcia.
It says Ray though.
If I recall correctly, Your Honor, I do believe he's a representative of VMG Properties. I think he's the owner of that company. I think it's a code matter at 9.
Oh, Ray Garcia.
If my memory serves me correct.
Okay, code is here. And then you have who?
Mr. Perkins, Ryan Christopher Perkins.
Oh, he was highlighted on mine like he was in custody. Okay, City of Lansing versus Ryan Perkins, 24-01624. Appearance case.
Elizabeth McNally on behalf of the City of Lansing.
Public Defender Justice Straub on behalf of Mr. Ryan Perkins.
Okay, Mr. Perkins has a no ops license. He must have been in custody at his last court date. How are we resolving this matter?
Your Honor, the notes that I have say that there is no offer unless valid, and when I checked last week, his license was still revoked. However, the public defenders informed me that he intends to go to a license restoration clinic on March 3rd.
Is this the one at Union?
Yes, Your Honor.
Yes, Your Honor.
No, we can reset it after that. It's March 13th. April 6th at 8:30. April 6th, okay? 8:30, at 8:30, okay, sir?
Okay, thank you.
No problem. You have any questions at this time?
No, no.
Okay, we'll get you a notice to appear. Anthony Delvon is here, and then you're done with Bridges. You ready for the
I just need to briefly speak with Ms. Crawford on both of them, and then it should be okay.
So you can start. You got the heavy hitters in here for the city cases. Yeah.
2 hours.
And then the one, so
Pretty apparent, eh? Think so.
Sir, we have muted
Yep.
you 3 times.
Oh,
You ready to go on Bridges?
yes.
On the record in the matter of the city of Lansing versus Jesse Bridges, 21-02183, 22-01836. Appearance, please.
Elizabeth Crook-Molly on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Bridges, who joins us via Zoom.
Okay, Mr. Bridges had a no ops and then a driving while license is suspended. Were you all able to resolve these?
Not as of today, Your Honor. We would be making a request for a brief adjournment. He has completed everything other than the test. That is a money issue for him right now. He advised he gets paid every 2 weeks. So if the court would allow 3 for him to get the money and take the test and get us the paperwork from that.
It's kind of hard to hear you guys.
I can say it again louder. You advise that he needs 2 weeks to get the money to take the test. So if the court would allow an adjournment of 3 weeks to get the money and take the test and present paperwork from that.
So he can get another permit?
So you can take the test to get the permit towards the full license. The city's looking to see the permit here.
And then if he gets a permit, then what?
If he gets a permit, then it would be amending the DWS to another no ops. So he would be pleading on 2 no ops charges.
April 6th at 9:30. April 6th at 9:30. Now, Mr. Bridges,
Yes, ma'am.
you don't have the best track record of returning to court. That's why we're dealing with a 2022 and a 2021 case in 2026. How are you going to remember to return back to court?
Okay, I came today. I told you it's time to get rid of the BS.
You ain't never lied. So the reason why I'm looking at your sealing of your cards because you're putting it on your calendar.
Pardon
On your
me?
phone?
No, because I told you it's hard for me to like hear you guys.
Oh,
Like right now,
Got it.
the volume is like all the way down, so I have to have my ear to the speaker.
okay. Well, make sure you put this date in the calendar on your phone, in your house, at your
Will I be
job, wherever you
Will
need
I
to
be
put it,
able to
okay?
come down there today and get paperwork for that?
You can come and get a copy of your notice to appear if you'd like.
Yes, ma'am. I'll be there right now then.
Very good. Any additional matters for the record?
No, Your Honor, thank you.
Nothing further. Thank you.
Thank you. You're all set.
Yes, ma'am. Have a good morning.
You too. And then you say you were ready with Mr.
Delvon.
Delvon. This is City of Lansing versus Anthony Delvon, 25L29-73781. Appearance, please.
Elizabeth Crook-Molly on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Delvon, who's joining us via Zoom.
Hey, Mr. Honor, I got paperwork from the car dealership. I was supposed to I was trying to call and let you guys know, but they gave me like a whole bunch of paperwork, like something like that.
For that paperwork, Your Honor.
You were gonna be requesting adjournment for,
We were gonna try to get that paperwork.
okay, this was for a registration code transfer. How
Yes,
much
Your
time are
Honor.
you looking for?
And they gave me this as well.
You're not long if he's got the paperwork I need to give over to the city.
That's available, right?
Yeah, thank you.
I mean, I can come down there today if that works for you guys and just give you the paperwork.
That works too.
Alrighty.
Fine with the state, Congress.
Yeah, if you can come now, then we can maybe get this resolved today, if you can come today.
All right.
Just in case you said anything.
I'll be on my way then.
Okay, thank you.
Yeah, you're welcome.
I'll go with that. Okay, and then.
Well, we already did Slayton.
Or not Slayton, it's man.
I'm sorry, man. All right, this is the case of the state of Ohio versus Donovan Mann, case number 25 CR 42531. Present before the court is Mr. Mann, right?
Yes, Your Honor.
We have Mr. Harrison, the prosecutor's office, and Officer Bridgman from probation. We're here today, Mr. Mann, because I have received a report that tells me that you violated the terms of your intervention in lieu of conviction in that you continued to test positive for THC. Did we get a negative or a positive test today, Officer Bridgman?
He was positive and admitted to using marijuana today.
All right, so Mr. Mann, you have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint a lawyer for you. My plan in this case, Mr. Mann, is, other than the weed, you seem to be doing fine, but I don't allow people to have intervention in lieu of conviction if they don't quit using drugs. So if you want to admit to this violation, I'm going to continue you on probation. You will have a felony conviction, but you'll just be on general probation. Do you understand that?
Yes, Your Honor.
Do you want to be represented by a lawyer?
No, Your Honor. I do have counsel. He's not here today, but I do have a lawyer.
Is that Mr. Fox again?
Yes, Your Honor.
All right, well, let's do this. I do find there's probable cause to believe you have violated the terms of your supervision, and we're going to set this for a final hearing. We'll reach out to Mr. Fox and get a date. Is there anything else we need to do today?
No, Your Honor.
All right, get in touch with Mr. Fox. We will also get in touch with him, and we'll set it for a final hearing before not too long. Okay, Mr. Mann?
Thank you, Your Honor.
All right, that's all.
Thank you.
That's my bad. I did not know that he hired.
Jeff, is this your file? Tyler?
It's a national arena.
Oh.
Oh.
I don't know who had me before, right?
Yeah, you did before.
Did I?
Hold on. We are still trying to figure out a computer issue.
Jeff, you did have them before.
All right, here we go. We are on the record this morning now for the 28th Circuit Court here in Wexford County, taking up the case of people of the state of Michigan versus Tyler Michael Rocheleau. This is file number 24-13982-FH. Here in the courtroom, I have got Mr. Sean Van Atmel. He is the probation officer on the file. Also joining me this morning via Zoom is the defendant, Mr. Tyler Michael Rocheleau. Sir, can you see and hear the court?
Yes, Your Honor.
Nope. There's no audio coming in from that side. We'll wait for the court to make sure it's coming in.
It's the jail. It's muted.
The jail, is there anybody there to your right, Mr. Rocheleau?
Yes, Your Honor.
Yeah, tell them they need to turn the audio on.
It's on.
There they go.
It's on. It's on though.
All right.
Um,
Hmm,
We're gonna kick you out. Why don't you try calling back in? Okay.
Recess in place. All right, we're back on the record for People versus Rochelle. Sir, are you able to see and hear the court?
Yes, I can, Your Honor.
Okay. Unless you are miming, most people don't know what a mime is anymore. Your audio is still not turned on.
I don't know.
The microphone is bouncing, so
Is what?
So I try yelling?
it's registering sound from here.
Okay.
So maybe it's our side. So I will close it and try again.
All right, folks, we are having all kinds of technical difficulties. Anyone who ever thought that using all this technology would make our court system work more efficiently was incorrect.
I just wanted to get in the Zoom room with them.
All right, let me see.
We will have a plea ready though, Judge.
All right, I'm trying to see where he is. Okay, I'll move you to his room, okay?
Thank you.
Hey, good morning, Miss Johnson. Are you with us all afternoon? Are you the prosecutor on this docket this afternoon?
Oh, I wish, Judge. No, I've just got Winderski.
All right, yeah, we have a bunch of child abuse and the computer crime cases up this afternoon. I thought maybe it was you.
They usually are. I wonder if those are fake dates because we moved all their exams to the 18th.
Today's the 18th.
Today's the 9th.
Ah, all right. Well, that explains why I can't find your other client. All right. Last name was what? Winderski? 9:30. Let me see if I have anyone here for that yet.
Yeah, he's in custody.
He's in custody.
Which one is that?
Winderski, but he's on Zoom.
All right. So we've got him here. We have him, but we don't have his attorney yet. So the jail isn't a breakout room though. So as soon as we get an attorney, we should hopefully be able to get moving.
Sounds good.
Thank you.
or intoxicants. And more specifically, it's alleged that on or about 4 allegations are, what your rights are, and then see how you wish to respond. On this request and warrant, it alleges 4 counts of violating the terms and conditions of your probation. Count 1 alleges that you violated special condition 2.0, which requires that you must not use or possess alcohol or other intoxicants. And more specifically, it's alleged that on or about February 3rd of this year, you used and or possessed alcohol. Count 2, 3, and 4 each allege a violation of Rule 1. Rule 1 of your probationary terms requires that you are not to violate any criminal law of any unit of government. For count 2, it alleges that on or about February 3rd of 2026, you operated a vehicle while intoxicated and or impaired. Count 3 alleges that on or about February 3rd of 2026, you operated a vehicle without insurance. And count 4 alleges that on or about February 3rd of 2026, you possessed open intoxicants in a vehicle. You have the right to challenge those 4 allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you'd have the right to be represented by an attorney, as well as at all subsequent proceedings. You'd have the right to have the prosecutor prove the allegations by a preponderance of the evidence. You also would have the right to review the evidence against you, question or cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose, and also the right to remain silent and the right to not have that silence used against you. If you cannot afford an attorney, the court will have a public defender appointed to assist you. If you're found to be in violation of your probation, you'll be resentenced on your original offenses. In this case, you were originally convicted of aggravated assault. That is a misdemeanor. A misdemeanor punishable by up to 1 year and or up to $1,000. You were also convicted of attempting to resist assault or obstruct a police officer. That would be a misdemeanor punishable by up to 1 year and or up to $2,000. And you are also convicted of malicious destruction of personal property in a value of less than $200, which itself is a misdemeanor punishable by up to 93 days and or up to $500, or 3 times the amount or value of the property that was damaged or destroyed. Because there are 3 non-technical allegations, the court is not limited to a sliding scale. For what are called technical probation violations, the court is limited to a sliding scale of 5 days, 10 days, and 15 days for your first, second, or third. However, because you are charged with 3 non-technicals, if you were found guilty of 1 or more of those 3, the court again would no longer be limited by the amount allowed. Would not be limited by the sliding scale, but would only be limited by the amount allowed under the law for the 3 offenses. Now, based upon these allegations, I suspect you have been charged criminally in another courtroom. Mr. Van Atwell, do you know if there have been any new charges filed based upon these alleged acts?
He was arrested on the 3rd, but released on a PR bond because he had to get evaluated medically, and he has court in 85th District, 219.
Okay. All right.
So he's charged, but
on bond.
Yes.
All right. So, Mr. Rocheleau, that means that if you request an attorney, I'll of course have one appointed, and I'll enter a not guilty plea. If I enter the not guilty plea or you enter the plea of not guilty, either way, we'll set it for an informal hearing. That hearing could take place later this week. However, I will tell you that I have a trial that's going to probably take the full next 3 days. So there's a good chance we wouldn't get to it until next week. at an informal hearing, the attorneys and you and Mr. Van Atmel will appear in front of the court and tell me what's going to happen. Are we going to have a contested hearing? Is there going to be a plea or resolution, or are the allegations going to be dismissed? I won't know that until we get to the informal hearing. Now, if there is no resolution at that informal hearing, we will have it set for a contested hearing, which is again in the courtroom where there would be witnesses. Generally, those take about 30 minutes to go through. Also, you want to keep in mind that anything you say today or in the processing of this case could be used against you in Benzie County. So you want to be very careful about not making any statements today that would be inculpatory or could be used against you. Now, so far, do you have any questions about what I've advised today?
No, Your Honor.
And do you wish to have the court appoint an attorney to assist you?
Yes.
The court therefore enters a not guilty plea on behalf of the defendant.
Pay 100 now. Pay 75 more by February 23. Can you do that?
Yeah, I could do that. Sure, next week.
And then I'll waive the balance for you, okay? So you pay 175, wash the rest, okay? Good luck.
So much. You have a great day.
I'll try. Thank you. N&D Properties versus Michael Baker, 2600243.
Good morning, Your Honor. Mark Land on behalf of plaintiff. Good to see you.
Good morning, Mr. Landau. Do I have Michael Baker here? Mr.
Yes,
Baker,
sir.
how are you? Your name?
Michael Baker.
Can you just stop right there? We're getting a good. There you go.
Yeah.
Did you list, by the way, again, whoever's just getting here, I had a court to school program and it went a lot longer than I thought. So my apologies if I kept anybody waiting here. Mr. Baker, did you listen to and understand the rights on the video?
Yes, sir, I did.
Do you wish to speak to an attorney?
No, sir.
Or do you intend to apply for funding?
No, sir.
Tell me the total amount owed right now, counsel, just the total amount.
The total amount that Mr. Baker owes right now is $1,097.04.
Can you pay that, sir?
Like I was speaking with Mr. Landau, this Friday I get paid, so everything will be caught up to speed, sir.
You sure?
Yes. I don't know what exact date Mr. Landau said, but that it will be all paid for.
You're saying you're going to pay it this Friday?
This Friday I do get paid, yes.
And you'll pay it that all in full that day?
I believe so. That I don't remember what date Mr. Landau said to me.
Listen to my question. Are you going to be able to pay it all by Friday? $1,097.04. If you do, I'm going to adjourn this a week. If you don't, then I'm going to give him a judgment. But I need your word on this. You're going to be able to pay him by Friday?
Yes, sir.
Are you positive?
Yes, sir.
I didn't hear you. I didn't hear you, Mr. Baker. Are you positive you can pay by Friday?
Yes, sir.
I'm going to adjourn it a week, okay, Mr. Landau? We'll adjourn this to the what do you have? What do I have next week, Jennifer Wiseman or Mikolos? I'm not here. I might not be here on Tuesday, so I don't know.
Next week, Judge,
why don't we do it the 18th at 8:30? What do I have? Woodhaven?
Woodhaven. Mm-hmm.
We'll do this the 18th at 8:30, okay? 18th at 8:30.
So be here 18 on the.
Pay all your
8:30?
money you're going to pay him by Friday so we can dismiss
Yes,
it,
sir.
right?
Yes, sir.
All right, but I'll adjourn that to the 18th at 8:30.
Thank
Okay?
you.
Pay him by Friday. Good luck.
Yes, sir. Thank you.
South Point versus Marquetta Brooks, 2600244. All right, do I have Marquetta Brooks here?
No, Your Honor.
All right, Mr. Landau, your appearance?
Mark Lando for the plaintiff.
Good morning, Mr. Landau. Again, give me your breakdown. I'll give you a default.
We're seeking the entry of a default judgment of possession for non-payment of rent. Just the rent portion is $842.23, $75 in late fees for a subtotal of $917.23, plus $182.04 in court costs. Total is $1,099.27.
Defendant failed to appear. The relief request will be granted. Default judgment of possession in favor of plaintiff and against defendant. The writ date will be on the 19th. I'm just going to ask you to give me those judgments this morning so I can get them signed, if you would. South Point versus Juliana Jones, 2600245. Is Ms. Jones here?
No, Your Honor, defendant did not check in.
All right, you paid for a second mailing. Mr. Landau, you can go ahead.
Your Honor, we're seeking the entry of a default judgment of possession for non-payment of rent. The rent owing is just the base rent is $1,683.06 plus $75 late fee for a subtotal of $1,758.06 plus $182.04 in court costs. Total is $1,940.10.
Defendant failed to appear. Default judgment will enter in favor of plaintiff and against defendant. Writ date will be on the 19th of February. The amount to be paid to save is $1940.10. South Point versus Kenneth LaRue II, 2600246.
Mark Lando for the plaintiff.
I don't see Mr. LaRue here either. You paid
No,
for
Your Honor, he did not appear.
You paid for a second mailing. You can proceed with the default.
We're seeking the entry of a default judgment of possession for non-payment of rent. The base rent is $1,011.11 plus $75 in court costs for a subtotal of $1,086.11 plus $182.04 in court costs. Total is $1,268.15.
Defendant failed to appear. Default judgment will enter. Writ date will be on the 19th of February. 1286815 is the amount to be paid to save us from the issuance. Threat. South Point versus Brenda Neal, 2600247. Is Brenda Neal here?
Defendant has not appeared, Your Honor.
Yeah, go ahead, counsel.
Mark Lando for the plaintiff. We are seeking the entry of a default judgment of possession for non-payment of rent. The base rent is $1,143.02. $75 in late fees for a subtotal of $1,218.02 plus $182.04 in costs. Total is $1,400.06.
Defendant failed to appear. The relief request will be granted. Default judgment of possession in favor of plaintiff against defendant. Writ date will be the 19th of February. And the amount to be paid to save it is $1,400.06. South Point versus Tanisha Tucker, 2600249. Ms. Tucker, your name?
Nisha Tucker.
Good morning, Mr. Landau, your appearance?
Mark Lando for the plaintiff. I met with Ms. Tucker in a breakout room and we've agreed to a consent judgment.
Okay. All right. You can go ahead and you listen to all the rights, correct, Ms. Tucker?
Yes.
So you're not gonna, you don't want to talk to a lawyer and you waive, you're not going to apply for funding either, true?
No.
Okay, go ahead, Mr. Landau.
Gunner, the base rent is $1,230.68. $75 are the late fees. So the subtotal is $1,305.68 plus $182.04 in court costs. Total is $1,487.72. And we're extending Ms. Tucker's pay or vacate date out to February 26.
Ma'am, do you agree that you owe that sum $1,487.72?
Yes.
You understand you have to pay that amount on or before February 26th or vacate. If you don't do either one of those, you're going to be evicted. You understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
Does Mr. Landau have your permission to sign your name to that proposed consent judgment?
Yes.
Any questions?
No.
All right. Consent judgment will enter. I'll wait for that today. February 26th and 26th will be the writ date. $1,487.72 is the amount to be paid to save it. Have a great day. Good luck. South Point versus
Thank you.
Deja Wilson, 2600251. Ma'am, your name?
Deja Wilson.
Good morning. Mr. Landau?
Mark Landau for the plaintiff. I met with Miss Wilson in a breakout room and we've agreed to a consent judgment.
Okay, and what are those terms?
She owes $641.22 in rent. She's already paid court costs, so her total is $641.22. She needed until the end of the month, till February 27, to catch up on that arrearage. So we've agreed to a consent judgment, giving her that additional time.
Do you understand and agree to those terms, ma'am?
Yes.
Do you understand and agree that you owe $641.22 and you have to pay that on or before February 27th? If you don't, you have to vacate. If you don't pay or vacate, you will be evicted. You understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment and 10 days to appeal. Do you understand that?
Yes, Your Honor.
Questions at all?
No, thank you.
And again, Mr. Landau has your permission to sign your name to the proposed consent judgment?
Yes.
All right, you're all set, ma'am. I wish you well. Good luck. Thank you. Riverside Townhomes versus Kim Morgan, 2600252.
Mark Landau for the plaintiff.
Is Ms. Morgan your name?
Kimberly Morgan.
You
There's
look like
also a
you're
consent judgment, Judge.
you look like you're ready to go downhill skiing or something.
Yeah, I work outside, so I've been bundling up.
All right. Did you listen to and understand the rights, ma'am?
Yes, sir.
Did you speak to her, and is there a resolution, Mr. Landau?
Yes, Your Honor, we've got a consent judgment.
Good. Okay, go ahead.
She owes $2,826.04 in base rent. $150 are the late fees for 2 months, $75 each month. The subtotal is $2,976.04. Court costs are $182.04. Her grand total is $3,158.08. And she needs a little bit of an extension to get that paid beyond the statutory period. So we're giving her through February 26th to either pay or vacate.
And do you agree that she owes $3158.08?
Yes, Your Honor.
And you understand you have to pay that or vacate by the 26th of February. If you don't do either one of those things, then you're going to be evicted. Do you understand that?
Yes, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, Your Honor.
Does Mr. Landau have your permission to sign your name to the proposed consent judgment?
Yes, he does, Your Honor.
All right. So the writ date will be the 26th. The amount to be paid to save is $315,806. You are all set. Make sure you take care of that. Have a great day and good luck. Thank you.
Thank you. You too.
Riverside versus Zachary Marion, 2600254.
Mark Landau for the plaintiff.
Is Zachary Marion here?
No, Your Honor, defendant has not checked in.
All right, so you can go ahead and take a default.
Your Honor, we're seeking the entry of a default judgment of possession for non-payment of rent. The base rent is $1,748.50. 75 are the late fees. 180. The subtotal then is $1,823.50. 182.04 are the court costs. The grand total is $2,005.54 with a writ issue if not paid in the statutory.
All judgment will enter. Writ date will be on the 19th of February. All right, do you have any more, Mr. Landau, or is that good?
That's all I've got, Your Honor. A quick question, though, on the one adjournment case, N&D Properties versus
I shouldn't have probably done that. I thought he was going to. I hope he pays by Friday. I'll feel bad if he doesn't. That was.
Why? If I'm able to reach a consent judgment with him,
I still got to have you do it in person, though. I'll be on here at 8:30.
Okay.
On the week from Wednesday. Okay.
We'll see you then.
Thank you.
All right. Have a great day. Good to see you.
Mr. Bodges' case?
I do.
Where's that file at? Can I have that one? Why did you show up here? I didn't intend for you to show up in person.
I saw Ms. Bryant show off last weekend or next week.
Okay. Do we have that file? What's your client's name?
Granite Valley.
Granite.
Depending on that, that's in the 930s.
All right, let's pull that. Do you have Granite?
That's all that I.
And you know, additionally.
This is the Hamptons. Wait a minute. I need,
It's all the 9.
That's all the 930s.
Hamptons is 9 o'clock, Judge. It would be after
9:30.
owners, Fountain West, then there's the Granite Valley folder, if they're in order.
I just gave you what was given to me.
this is the Hamptons.
Yeah, it says 930.
You have it at Granite?
Ridley, case number 25 CR 43173. Present before the court is Mr. Ridley, correct?
Yes, sir.
Represented by Mr. Helbling, and we have Mr. View from the prosecutor's office. It's my understanding Mr. Ridley is going to enter a plea of no contest to 1 count of failure to comply with the order of signal of a police officer. We're setting this for sentencing in about 6 to 8 weeks. Is that right?
Yes, sir.
Yes, Judge.
Mr. Ridley, how old are you?
I'm 29 years old.
How far did you go in school?
I completed high school and I got some college. I went to electrical
Are you able to
college.
read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What we're going to do is we're going to conduct a level 2 pre-sentence investigation. We're also going to do an evaluation to determine whether or not you are appropriate for a community-based corrections facility. My general inclination, Mr. Ridley, for folks who run from the police is to send them to prison, but I don't do that in every case because every case is different. Sometimes we do a period of local incarceration followed by some probation, but I really don't know until I see the PSI. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
Your Honor, for the record,
Have a document?
Your Honor, for the record, it's no contest, not guilty.
Oh, that's right. No contest. I'm sorry.
Sorry.
All right. I have a change of plea and entry here. There's a signature on the second page above the line defendant. It appears to say Gary Ridley. Is that your signature?
Yes, sir.
Did you review this with Mr. Helbling before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of no contest to 1 count of failure to comply with the order of signal of a police officer. It's a 3rd-degree felony punishable by up to 60 months in prison and a $10,000 fine. If I do send you to prison, the maximum period of incarceration also includes a mandatory period of post-release control. That means that the adult parole authority can supervise you from anywhere from 1 to 3 years. And if you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing any felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and automatically consecutive to the sentence that you would receive for the new felony. This also carries with it a Class 2 license suspension of anywhere from 3 years to life. Before we go any further, Mr. Ridley, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of no contest, you're going to give up all of these rights. You're going to admit the facts of this case, although a no contest plea means that you don't necessarily admit that those facts constitute a criminal offense. And assuming the facts are sufficient, I'm going to find you guilty and we're going to get on with the matter of the sentence. You understand all of that?
Yes, sir.
Is this what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on November 8th of 2025, approximately 1 a.m., the city of
in the city of Franklin, Warren County, state of Ohio. Franklin police officer Nathan Mader was doing routine patrol. He observed a vehicle driven by the defendant to make an two unsignaled left turns. Initiated a traffic stop with lights and sirens. The defendant fled through the city of Franklin at speeds of more than 100 miles per hour, turned off his operating lights on his vehicle, and fled northbound on I-75 at speeds, again, in excess of 100 miles per hour, was weaving through traffic, ultimately got off at State Route 73 and came to a stop. The defendant was taken into custody there. He also ran a red light before he got onto the highway. After he was pulled over, he was taken into custody and given his Miranda rights. The defendant admitted that he was smoking marijuana just before the pursuit, and he fled because he was afraid.
Anything on those facts, Mr. Helbling?
Nothing on the facts except the smoking allegedly took place in Dayton on the video that I saw.
All right, Mr. Ridley, did you hear those facts?
Yes.
Do you admit that they are true?
Yes, sir.
Do you understand the rights that you're giving up by entering a plea of no contest?
Yes, sir.
What's your plea?
No contest.
I am going to accept your plea of no contest. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to go ahead and remove you from electronically monitored supervision today, convert you to pretrial supervision. So you'll be off the monitor, go down to pretrial, fill out the paperwork for the PSI. We'll see everybody back here in about 8 weeks. Anything else for today?
No, Your Honor.
No, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, we're in recess.
Televalley in a separate folder?
It should be in its own folder that says Granite Televalley. Each complex should have a folder. And Judge Miss Cohen, because you were at court to school, is still talking to a few tenants on the 9 o'clocks anyway. So she's still got a few more people to talk to.
Televalley was not 10 o'clocks.
Good, thanks. Granite Televalley versus Ronald Allen Bodges, 260001.
John Capitan, P60901, during a complaint of Granite Televalley.
Your name, Mr. Bodges?
Bodges.
Now you didn't have any alcohol today, right?
Sure.
You sure? All right, what do we got here?
Okay, Your Honor, this is just cause termination.
Yeah.
Mr. Bodges, back in November, I believe it was November 1st, he assaulted 2 residents at the community. This isn't the first time either. This has been an ongoing issue. I mean, I have police reports dating back from, I have one from December 24. I have trespass.
Is that the serious case that's pending as a felony?
Yes, this is the one where one count is assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with dangerous weapon, felonious assault. Count 3, assault with dangerous weapon, felonious assault. And last but not least, habitual offender. 4th offense, notice mandatory 25 seconds. Your Honor, the community is tired of having SWAT teams come over. Residents are complaining. It's unfair to the residents. We asked the court to terminate the residency of Mr. Bodges.
Mr. Bodges? Yeah. Do you have anything to say?
Well, he just said, I saw 2 people I know. Remember, there's only one person there. He tried to assault me in my own home. He got his ass whooped.
Hang on, don't talk like that. It's a courtroom.
Anyways, he got beat up. Want to take me out for that. I said, it's self-defense, Mom. I got a court date. For all these charges that he read. Most of them not even there. He don't know what he's talking about. And so I'm gonna beat that case, Your Honor. I need to go March 7th to do that case.
This is you rent, correct?
What we're trying to allow. Suzanne wants my home.
No, Suzanne does not want his home. Suzanne wants to have a community member who doesn't disrupt the quiet peace.
No, I know, I get it, Mr. Capitan, but here's the problem Mike got right now. I don't want to be asking him a bunch of questions. He's got the right to remain silent. I don't know whether he intends, don't say anything, Mr. Hodges. I don't know whether he intends to say anything or not, or testify or not. Is that March 7th trial or is that March 7th pre-trial?
Might be pre-trial or trial. For sure. March 7th, time. I think the guy's got to show up there. Right there.
This isn't even about Mr. Mr. Bogdan. I'm sorry, I'm speaking.
Hang on.
This isn't even about Mr. I'm speaking, sir.
Mr. Hodges, settle down. Before you go anywhere, Jennifer Wiseman, would you do me a
Yes, Your
favor,
Honor.
please, or Jennifer McLose? Would you call Amy and ask her to check and see what that case is scheduled for, please?
Judge, I'm pulling up Third Circuit's website right now and looking to see if I can.
Good. All right, go ahead, Counsel.
Well, I was going to say, Your Honor, whether or not Mr. Bias gets convicted of this or not, what we have here is a disruption in the community. This has been ongoing. This isn't even it's not even the first time. Obviously, I've told Your Honor I have about 7-8 reports here throughout the years since 2022. This is an ongoing issue. It's not even about him being convicted. It's about having the disruptions, having the police presence in the community. I mean, he just admitted that he was in a fist fight right at his house. So I think that that's enough to provide for cause for termination. I mean, and I'll take judicial notice of.
What if he's acquitted of it?
Well, if he's acquitted, it doesn't matter.
Wait a minute.
This is a civil case. I mean, if you take a look at it,
You're alleging that he physically assaulted another resident of the community with a baseball bat. That's what your allegation says.
My allegation is that he was arrested in November.
Well, that's what I'm reading off of your notice to quit here.
Yes. Yeah, that he assaulted another resident. That's correct, with a baseball bat. Whether or not it's self-defense or not, what we have here is Mr. Bogus telling the court, hey, I was in a fist fight. He admitted it. He spoke. I did. So I think what we have before the court is we have November 3rd.
The law is not an ass, you know? If this was truly self-defense, I'm not saying it was. I'm not saying it wasn't. I'm in a pickle because I'm not going to be asking him questions today. That's not fair. That's not appropriate for a judge to be asking a defendant questions regarding a criminal case that he has pending because he has the right to remain silent. It's not appropriate. It's not something I'm going to do. In fact, I don't know how I'm going to. And listen, Mr. Bodges is not high on my totem pole here. I mean, he shows up to court drunk. He was on there yelling F this, whatever, on Zoom here a couple of weeks ago. So this is not about me thinking that Mr. Bodges should be in the church choir. That's not what I'm talking about. I still have a function, a responsibility, and I'm not going to breach that by throwing this guy out without a hearing. I'm not going to breach that by assuming that he is going to be convicted. I'm not doing it. I'm just not doing it. I'll be glad to. Have you figured out what that is, Jennifer?
Yes, Your Honor. So it looks like there's a final settlement in February, or a final conference on 2/19 and a jury trial on March 4th.
Okay, good. Then we're going to adjourn it to right after. I doubt it's going to settle based on what he said. If it does, I'll be glad if you find that out, Mr. Capitan, to call the court and say, ask the judge to give us an earlier hearing. But I'm gonna be gone on the 4th, I believe, right, or the 5th? So we're gonna have to do it when I get back.
Right, I know you have vacation because there's another case where we're gonna go out to the property. Yeah, you have vacation.
Right. So I can do it like, what day am I coming back? I don't even know.
You'll be back on this for the 16th.
Yeah.
Well, then let's do the 16th, okay? 16th of March.
Judge, do you want it later in the morning if you're gonna have testimony possibly?
And also,
Like 10:30?
Yeah.
Isn't it the day that you're going out to another property?
I don't know.
Yeah, pretty sure.
Is it?
Because it's my property.
What time?
I thought it was, gosh, what's,
Early.
it was like
Early?
30, yeah.
I'm gonna know what the jury verdict is that day. I don't know if I'm gonna need testimony. March 16th at 11. Let's do 11 o'clock in the morning.
Okay, Your Honor.
But I don't want you to have to sit around here too much either. Do you know what time that is? Are you going out to meet me is the point, counsel?
Yes. Yeah.
Do you know what time that is?
Yeah, it's like 8:30.
Well, then let's make this 10:15. How's that? Time we get out there and look and come back.
So that's also another.
All right, that's what I'll do on that. Thank you. You understand everything that's going on? No, March 16th at 10:15. March 16th at 10:15, the day before St. Patrick's Day. March 16th at 10:15. Good luck. We'll see you here then. You have this other one, right, Counsel Grant?
They have two other ones. They have Fountain West and,
You have Granite Tell Valley versus Joshua Summers, right?
correct.
260046. Everybody's name here is here. Or here.
I don't have them checked in, Your Honor.
Okay, well, that was scheduled for what time? 9:30.
9:30.
Yeah, so he was given 15 minutes. Go ahead.
All right, John Capitan appearing on behalf of the plaintiff, Granite Teller Valley. We move for a default judgment of possession. Breakdown is rent is $2,067.73. Then we have late fees of $105. That is 3 at $35 each. Filing and service fees of $116.11. And attorney's fees $75 for a total of $2,363.84. We have set a writ issue after February 19th on my judge.
You appeared on this. You prayed for a money judgment, did you?
Oh, no money.
No, you
judge.
did not.
No money judge.
Writ date will be February the 19th. The amount to be paid to save it is $236,384. Right?
Yes.
Okay, that's it. You're all set on that one. What's the other one you have?
Fountain West versus Alexis.
Do you have that, Fountain West, John? Can you grab that one and I'll get Mr. Capitan out of here?
They should all be that.
I got Hamptons here and Hamptons.
They're just gonna transfer 11 out here.
You have Fountain West? Is that I got a separate folder, Jennifer?
Yes, Your Honor. Each complex has a folder.
No, these are on the damn flag.
That's all right. No worries. Fountain West versus Alexis Green, 2505212.
John Capitan appearing on behalf of the plaintiff.
Is Alexis Green here?
I've not had, yes, she is, Your Honor. She should be joining.
Alexis Green, you have to state your name, start your video, please.
Hello.
Okay, wait a second now. Wait a second. Where are you, ma'am?
I'm right here.
I know, okay, I know, but I gotta have you, oh my gosh. I'm gonna get busy here. You're completely upside down. Okay, can you just stay there and hold that?
Yeah, I'm on the iPad. I'm sorry.
All right, just stay right there. Just hold it steady for me, okay? All
Okay.
right, your appearance.
All right, John Capitan, appearing on behalf of the plaintiff, Fountain West Apartments.
Ma'am, your name?
Alexis Green.
All right, so you were here, you said you wanted to speak with an attorney and applied for funding. Did she submit an application for funding, Jennifer?
Judge, I'm double checking, but we
Did you submit your application for funding to the court, Ms. Green?
No, I didn't submit it to the court because I had submitted it. I mean, I had applied online and I was waiting on them to send me a approval letter in the mail, and they haven't sent anything just
I
yet.
told you you had to file that with the court.
Yeah, but how can I file anything if they haven't sent me the letter yet saying if I was approved or not?
That is not what I asked you to file with the court. I asked you to provide a copy of the application. Have you heard anything from them?
Not yet, but I did receive a payment from them because I do get cash assistance from them every month.
Go ahead. I'm going to give you your judgment. I told you had to submit that application for funding. You
Okay.
can't do that. I think I was really clear about that. Go ahead. I'll give you your judgment.
And rent is $3,573. 3 late fees of $50 each, so that's totaling $150. Finally, in service fees of $105.54 and attorney's fees of $75 for a total of $3,904.54.
All right. You agree that you owe that amount?
Yes.
I'm just going to count this as a judgment for plaintiff after hearing $3,904.54. You going to be able to pay this
Yes.
by the 19th?
Not by the 19th, maybe like before the 24th, because they sent me a letter saying I had until the 28th to pay it because it's actually time for me to renew my lease. So I have to pay it before then or I can't renew the lease or whatever. So I was going to pay it in full because they actually have the account locked. So I'm not able to make partial payments.
If you pay $2,000 by February 19th, I'll extend the writ date until the 24th.
Okay, how can I pay it if they have the account locked?
I'll tell them. Well, if the account, well, you're gonna have to pay by money order. I mean, obviously, when you don't make your payments.
Why are they locking the account on a non-payment
You know,
case?
this happens in almost every single client I have is when somebody's late, the electronic payments online, it's locked out.
Yes, you're not able to make
Yeah.
partial payments. Because like I said, I received the payment from DHS this morning, but I can't even pay nothing because the account is locked.
Well, the partial payments I understand because of the Court of Appeals case, the part.
Yeah, but that's for termination of tenancy. This isn't for termination of tenancy.
No, I thought that was a non-payment, right?
No,
Where they accepted money.
no.
Yeah.
Ma'am, you pay $2,000 by the 19th. He's going to take care of that. If you pay $2,000 by the 19th, bring it into your landlord, then your writ date's extended until the 24th, okay? But you
Okay.
got to pay $3,904.54 by the 24th. You understand that, right?
Yes.
All right. I wish you well. Good luck. You're going to take care of that for me, right?
Yep.
All right. Have a good day. Thank you. And make
Okay.
sure you get those judgments to me today, if you would, please.
I will, Your Honor.
Thank you. Hamptons versus Emil Springer, 2600307.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Mr. Springer, your name?
Emil Springer.
Did you listen to and understand the rights on the video?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir. I already spoke with the lawyer for the Hamptons.
Do you intend to apply for funding?
No, sir.
All right. Did you guys reach an agreement?
Yeah, I have a
Yes, sir.
consent judgment to put on the record, Your Honor.
Okay. Is it a consent?
Yeah, we've agreed that there is a total of $1,180.10 owed in rent, $170 late fee, $75 in court costs, for a total of $1,325.10. And Mr. Springer has agreed to pay those amounts by February the 27th, 2026. And he gave me permission to sign his name and electronically submit it to the court.
Is that true, Mr. Springer?
Yes, sir.
So you agreed to let her sign your name to the document, allow her to sign your name to the document. You're agreeing to enter into a consent judgment for 132510 with the balance due by the 27th, correct?
Yes, sir.
You understand if you don't move out, you don't pay by that date, you will be evicted.
Yes, sir.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, sir.
All right, I wish you well, sir. They'll submit the consent judgment and just make sure you get her the money by that date, okay? Thank you.
Yes, sir. Thank you so much.
Hamptons versus Lene A. Mitchell. Lene A. Mitchell, 2600308. Where's Lene Mitchell? Is she here? I don't see her.
Your Honor, she did not check in with us.
Okay, you have paid for a second mailing and go ahead and take a default.
Yes, I am requesting a default judgment, Your Honor. There's currently $1,076.54 in rent, $170 late fee, a $75 court cost for a total of $1,221.54 with the writ to issue after February 19th.
Defendant failed to appear. The writ date will be February 19th. Default judgment entered in favor of the plaintiff for the amount to be paid to save it is $1221.54. Hamptons versus Derek Brooks, 2600309. It's Derek Brooks here. I don't. Yes.
Yeah, Derek Brooks is here.
Sir, your name?
Derek Brooks.
Did you listen to and understand the rights on the video?
Yes.
Did you reach an agreement with him, Ms. Cohen?
Yes.
What is it?
We've agreed that there's a total of $1,304.62 owed in rent, $170 late fee, $75 in court fees for a total of $1,449.62 with a writ to issue after February 19th if those amounts are not paid.
All right, sir. Does she have your permission to sign your name to a proposed consent judgment calling for you to pay $1,449.62 by the 19th of February?
Yes.
And you understand you have 3 business days. Since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment, you have 10 days to appeal. Do you understand that?
Yes.
Any questions?
No, I don't have any questions.
All right, you're all set. Good luck to you, sir.
Okay, thank you.
Hamptons versus Tasha Kegler. I'm sorry, 2600310 Kegler. She's on there. Ma'am, start your
Yes.
video, state your name.
My name is Tasha Kegler.
You have to start your video, please.
Oh, how do I start it?
Bottom left-hand corner of your screen.
Your
Okay,
Honor,
that's it.
she did not unmute when I was put in a breakout room with her. So could you pass this and I'll talk to her after I'm done with my other cases?
Yeah, we can do that.
Thank you.
Hamptons versus Latanya Gant, 2600311.
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor.
Is Latanya Gant out there?
Yes.
There you are. How are you, ma'am? Your name?
Good. Latanya Gant.
Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer or do you intend to apply for funding?
No.
Is there a resolution on this?
Yeah, I reached a consent judgment with Ms. Gant.
Okay, state your appearance and tell me the terms, please.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor. We've agreed that there is a total of $2,427.04 owed in rent, $270 late fees for a total of $140 in late fees, $176.54 in court costs for a total of $2,743.58. Ms. Gant has agreed to pay $1,371.79 by February the 20th, $1,371.79 by February the 27th. She has given me permission to sign her name to this and electronically submit it to the court.
I'm sorry, did you say 1371.79 for each of the payments? The first due by the first is February 20th. When's the next one due?
February 27th.
Okay, ma'am, do you agree to those terms?
Yes.
You understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, sir.
And again, does Ms. Cohen have your permission to sign your name to this proposed consent judgment?
Yes.
All right, so judgment will enter. The amount to be paid to save it is $2743.58. You have to pay $1371.79 by February 20th with that same amount balance due by February 27th. I wish you well. Have a nice day. Good luck. Thank you.
You too. Thank you.
Hamptons versus Tomoko White, 2600312. Ma'am, good morning. Your name?
Tomoko White, good morning.
Did you listen to and understand the rights, ma'am?
Yes.
Do you wish to speak to a lawyer or apply for funding?
No.
All right, Ms. Cohen, your appearance?
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor. We reached a resolution. I have consent judgment to put on the record.
Okay, go ahead.
There is $2,749.83 owed in rent, $250 late fees totaling $100 in late fees, $176.54 in court costs, for a total of $3,026.37. Ms. White has agreed to pay $1,500 by February 20th, $1,526.37 by February the 27th. She has given me permission to sign her name to this and electronically submit it to the court.
So she's paying $1,500 by the 20th and then in the balance by February what?
27th.
Is that, you agree to those terms, Ms. White?
Yes.
So you understand that you have to pay a total of $3,026.37, and that has to be paid as follows: $1,500 no later than the 20th. If you do that, the writ date will be extended until the 27th, in which case you'll have to pay the balance. Do you understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
Any questions?
No.
And again, she has your permission to sign your name to this proposed judgment?
Yes.
You're all set, man. I wish you well. Best of luck to you. Thank you.
Thank you. Bye.
Jessica Bland, Hamptons versus Jessica Bland, 2600313. Is Jessica Bland here?
Your Honor, Jessica Bland did not check in with us.
All right, you can take a default here, counsel.
Yeah, Carolyn Cohen appearing on behalf of the plaintiff. I'm requesting a default judgment. There's currently $1,254.54 owed in rent, $170 late fee, $75 in court costs, for a total of $1,399.54 with a writ to issue after February the 19th.
Defendant failed to appear. Default judgment will enter. Writ date will be February 19th, and the amount to be paid to save it from the issuance of the writ is $1,399.54. Hamptons versus LaCrystal Lovett, 2600314. I don't see her out there. Is she out there?
Yeah, she was here.
Yes, I'm here.
Okay, your name, ma'am?
LaCrystal Lovett.
Did you listen to and understand the rights?
Yes, I did.
Do you waive your right to a lawyer?
Yes.
Do you intend to apply for funding?
No.
Do you, Ms. Cohen, your appearance?
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor. I have a consent judgment to put on the record.
Okay, go ahead.
We've agreed that there's a total of $1,489.54 owed in rent, $270 late fees for a total of $140, $176.54 in court costs for a total of $1,806.08. And Ms. Lovett has agreed to pay $903.02 by, what was the first date, Ms. Lovett?
To be the 19th?
Yeah, by the 19th, I apologize. And the balance of $903.04 by March 2nd.
Do you agree to those terms, ma'am?
Yes, I do.
All right, you agree that you owe $1,806.08.
Yes.
And you understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, I do.
All right, and does Ms. Cohen have your permission to sign your name to this proposed consent judgment?
Yes, she does.
All right, judgment is entered, 1806.08. Writ date will be on the 19th. If you pay 903.02, the writ date's extended until March 2nd, at which point you have to pay the balance, which is not 1903, 903.02, it's 903.04.
Yes, I apologize. It's
That's okay,
903.04 for
on both of those. Okay, ma'am, you understand all that?
Yes, I do.
All right, I wish you well. Good luck. Thank you. Hamptons versus Perry Walker, 2600315. Walker?
Yes, I'm here.
Start your video. There you go. Take your hat off, please, and state your name.
Perry Walker.
Did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer or apply for funding?
No, sir.
All right, Ms. Cohen, your appearance?
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor. We've agreed that we've come to a consent agreement. We've agreed there's a total of $1,475.02 owed in rent, $170 late fee, $75 in court costs for a total of $1,620.02. And Mr. Walker has agreed to pay those amounts by February 23rd. He's given me permission to sign his name to this and electronically submit it to the court.
Is that right, sir?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. You understand that?
Yes, sir.
Agreement is you'll pay that $1620.02 no later than the 20th, correct?
Yes, sir.
He has your permission to sign your name to the proposed consent judgment, true?
Yes, sir.
All right. I wish you well, sir. $1620.02, pay by the 20th. Good luck to you. Derek Brown.
Okay.
Derek Brown. This is Hamptons versus Derek Brown, 2600316. Mr. Brown, good morning to you, sir. Your name?
Derek Brown.
Did you listen to and understand the rights?
Yes.
Do you wish
Yes,
to
Your
speak
Honor.
to a lawyer or apply for funding?
No, Your Honor.
All right, Ms. Cohen, your appearance.
Carolyn Cohen appearing on behalf of the plaintiff. We have a consent judgment whereby Mr. Brown agrees that he owes $2,160 in rent, $270 late fees for a total of $140, and $176.54 in court costs for a total of $2,476.54. Mr. Brown has agreed to pay $600 by February the 19th. $1,000 by February the 23rd, and $876.54 by March the 2nd. He gives me permission to sign his name electronically and submit it to the court.
Is that true, sir?
Yes, Your Honor.
So you agree that you owe $2,476.54 and that you're going to pay $600 by the 19th, $1,000 by February 23rd, and the balance by March the 2nd, true?
Yes, Your Honor.
So long as you make each and every one of those payments timely, you can stay in the property. If you miss any one of those, you're going to be evicted if you have not vacated. Do you understand that?
Yes, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, Your Honor.
Any questions?
No questions.
All right. I wish you well, sir. Good luck. Thank you. Hamptons versus,
Thank you.
I don't think I see Jayla Allen or Jennifer Hurd out here, 2600317.
That case was dismissed, Your Honor.
Okay, case, you're moving to dismiss this case?
Motion to dismiss without prejudice, yes.
Case dismissed motion. The plaintiff Hamptons versus Shalaya Chen, 2600318. I don't see that person out here.
Yeah, she's
right here.
There you are. Okay, ma'am, your name?
Shalaya Chen.
Good morning. Did you listen to and understand the rights?
Yes.
You waive your right to a lawyer, and do you decline to apply for funding?
No, I don't. I don't plan on to apply for funding.
Okay, Ms. Cohen, your appearance?
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor. We have agreed that there's a total of $1,033.08 owed in rent, $170 late fee, $75 in court costs for a total of $1,178.08. And Ms. Shin has agreed to pay those amounts by February the 19th.
Is that right, ma'am?
Yes.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
Do you have any questions?
No.
And she has your permission to sign your name?
Yes.
And you understand you have to pay in full or vacate by the 19th, true?
Yes.
Okay, I wish you well. Good luck. Thank you.
Thank you.
Hamptons versus Maya Baker, 2600319. Maya Baker.
Move for dismissal without prejudice.
Dismiss motion of the plaintiff. Hamptons versus Paris.
Sir.
Paris Long Kendrick, 2600320.
Carolyn
Yes, sir.
Cohen- Carolyn
How you
Cohen-
doing?
I'm doing
I'm
good,
sorry.
sir. How about you?
Good. Your name, please?
Paris Lorenzo Long Kendrick.
And Ms. Cohen, I'm sorry. Your name again?
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor.
All right. Is there a resolution?
Yeah, I have a consent judgment to put on the record.
Okay, go ahead.
We have agreed that there's $617.24 owed in rent, $170 late fee, $75 in court costs, for a total of $762.24 with the writ to issue after February the 19th. And Mr. Kendrick did give me permission to sign his name to this and electronically submit.
Do you agree that you owe that amount, sir?
Yes, sir.
You understand if you pay the $762.24 by the 19th, you can stay in the property. However, if you don't pay or vacate by that date, you would be evicted.
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand all that?
Yes, sir.
Any questions?
No, sir.
All right. I wish you well, sir. Good luck to you. Thank you.
Okay.
Hamptons versus Brian Walker, 2600321. Brian Walker here.
No, Your
Wow.
Honor, defendant has not checked in.
You want to take a default, right?
Yes.
Go ahead.
Carolyn Cohen appearing on behalf of the plaintiff. I am requesting a default judgment. There's currently $1,275 owed in rent, $150 late fee, $75 in court costs for a total of $1,400 with a writ to issue after February the 19th.
Defendant failed to appear at default judgment 1. A writ date will be February 19th. The amount to be paid to save it is $1,400. Is that it for you?
Well, here's the thing. I got, there's 2
Oh, you
other
got the one
attorneys here.
still. You got the ones.
Yeah, I've got to go back with,
Cakeless.
yeah,
Go ahead. No problem. Thank you.
thank you.
Wait a minute. Do I have more with, do the Hamptons have more?
Yeah, the man.
They do, Your Honor, but Mr. Visconti is handling the 930s and he is talking to a few more people.
See, okay, good enough.
There should be a file folder though for an owner's management case.
Yeah, I got it right here. I'll call that one next, and then I'll wait for you to come back on Kegler, Ms. Cohen.
Thank
And I'll
you.
take Mr. Visconti's then. Owner's Management versus Stephanie Drotar, 2600324.
Good morning, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management.
Good morning, Mr. Lechner. Do I have Stephanie Drotar here? I don't think so. She's not out there, is she, Jennifer?
No, Your Honor.
All right, you paid for a second mailing. You can take a default, Mr. Lechner.
Thank you, Your Honor. The rent to retain is $272 per month. There's currently 3 months due and owing for rent to retain $816. Costs are $222.11, and that's a filing fee of $106.11, service fee of $41, statutory legal fee of $75, and there's currently $94 in late fees owed dating back to December 5th. I'm sorry, yes, December 5th, for a total $1,132.11 with a writ date of February 19th.
Defendant failed to appear. Default judgment winner. Writ date will be the 19th of February. 113,211 is the amount to be paid to save it. Owners Management versus Justice Spicer, 2502423.
Good morning, Your Honor.
02423.
Good morning, Your Honor. Attorney David Lechner on behalf of Owners Management.
What do we do on this?
Your Honor, this is I filed in December. Ms. Spicer and the parties agreed to a probationary period back in I want to say October of last year, and it was our contention that Ms. Spicer violated the terms of her lease in December. I filed a motion to reinstate the case. We then withdrew that motion on December 22nd. We had a hearing. I withdrew the motion at that time. What I did do at that time, though, is I put on the record, because I spoke with Ms. Spicer and there was some confusion. One of the issues was that there was a unapproved animal on the premises. She said it wasn't hers. But I told her that it doesn't matter who owns the dog. You can't have an animal that's not approved in the unit. But we withdrew the motion at that time. I also put on the record that any further violations of the record, however severe or trivial, was going to trigger what we're doing today. And 7 days later, the allegation is that she violated the lease. So we filed this. I spoke with Ms. Spicer last week. We couldn't come to a resolution, so I think we need to set this for a trial.
Can I speak?
Hang on one second.
No.
I'm gonna need the conditional dismissal. Do we have it down there somewhere?
Judge, I
handy,
was just
Jim?
pulling up the file cabinet and I can print.
Yeah, I'm gonna need you to. I'm
Okay,
sorry.
no problem. No, not a problem. Just give me a minute.
Take your time. What is the allegation? What did she violate allegedly?
The allegation in right now is that she left garbage on the ground outside the dumpster, violating section 10B3 of the lease. And since that time, since I filed this, it's come to my attention that she has also had a unapproved resident in the unit with her, which would be brought up at the time of the trial. That wasn't in my filing on this, but we have photographic evidence of garbage outside the dumpster, ripped open.
Did somebody see her put it there?
I don't know that. But there was mail in the garbage to her address. That's how it was determined that it was her garbage.
She put garbage outside the dumpster.
Yes, Your Honor.
Asking you.
Yeah. Can I explain the situation?
Yeah, I want to hear it.
Listen, so I haven't even been at my house. I've made it clear, Walnut Creek, the person in my house was my ex-boyfriend that I allowed to come over. And he never left, basically. It's a whole domestic situation. He put that trash there because he's been at my house, but that's beside the point.
Aren't you living there anymore?
I still live there, but I haven't been there in like a couple weeks.
Where you been?
I've been at my cousin's house.
Doing what?
Literally, I was told not to go home by Flat Rock Police because my ex-boyfriend, he's making threats to me, saying that he's gonna kill me, he's gonna do this, he's gonna hurt my son, do all this. I have police reports that I turned into Crystal. I've been begging her for over a month to move my apartment, scared for my life, not even going back to my own house. And instead of moving my.
Who is this guy?
My safety.
Slow down.
They want.
Slow down. Slow down. Why are you talking over me? When I tell you to slow down.
I'm really upset.
Who is
picking up?
Ma'am? Who is this character?
His name's Richard.
Richard what?
Hollyburton, and he has a court case here in a few days for breaking my cousin's ribs. And I've been telling him.
Slow down. Slow down. Ma'am, I'm going to cut you off here if you don't. You're not going to interrupt me now. I'm going to help you, but you gotta listen, and you can't interrupt me, okay? All right? When did this guy start to come to your house?
Around Christmas time, and every time I call the cops will say he's been there more than 3 days, we have to evict him. So I've been trying.
How long has he been there?
Since like I said, around Christmas time.
So he's been there for December and January?
Yeah, and I've left my house. And I've came, like, every time, I haven't even been in my house like that. Every time I've come back, I had to bring the police there to escort me in to get stuff. Every single time that I call the cops. Oh, okay. You have to evict him. You can't make him leave. He's been there a couple days. Hello. And when I tell Crystal, I've been telling Crystal about the situation. The lady at the office, she's not any help. Any help at all. They just want to kick me out instead of helping. He's at my house now.
Wait a minute. Slow down. He's not there now?
No, he's finally out of my house. But I still haven't been there because Walnut Creek just a few days ago, they came to my house with an electrician and he left the door unlocked.
Let's slow down. Let's just slow down. Did he give you the key then?
No, my key's locked inside of my house. Walnut Creek locked my door because when he left it unlocked. So I haven't even been able to get in my house over the weekend already. I had to borrow clothes.
Just slow down. Now, promise. Why'd you let this guy in the house to begin?
Right. I didn't even know like that.
I can't hear you.
I didn't know that, and you start, talking and
How long have you known this guy?
not even very long. I met
I
him
don't know what that means. Not even very long. Some people,
like in October.
and did you invite him to live in your house?
No.
Has he vacated the property? Does he have any of his clothes there, to your knowledge?
I don't know.
Well, as far as I'm concerned, he's vacated, and I don't see any reason why she can't go back. If he left the property, he's got nothing there. How long's he been gone?
He just left a couple, 5 days ago.
Mr. Lechner, this seems a bit trivial to me, okay?
Your Honor,
Talk about-
I don't, sorry.
A bunch of police reports and everything.
I mean, I'm sorry, but trying to evict somebody because they left some rubbish outside the dumpster seems like about as trivial as anything. Now, I don't know what's going on there, but I believe this young lady. She looks like she's frightened to death. You got to be careful who you're inviting to stay with you.
Your Honor, if I may, I agree that it is trivial. And if it was just a garbage situation, we wouldn't be here. But the original situation that we were going to trial on in October was because Miss Spicer damaged someone else's property, a car, and then chased after damaged a car.
Hanging out with the wrong people.
And Your Honor, just furthermore, I'm looking at a police report and I realize it's not evidence. But this police report is dated from December 23rd of last year, a day after we were last in front of you. And according to the police officer, it said, according to this report, it says, upon arrival, Officer McCardle spoke with Justice Marie Spicer. Spicer stated Richard Antonio Halliburton was living with her for 2 months. So according to her statement to the police over 6 weeks ago, Mr. Halliburton had been living there for 2 months already. And he was
Is that true, ma'am?
That is true that I told the cop that, but I gave him a rough estimate because I was going through a bunch of stuff.
Slow down. You said you met the guy in October. When did he move in with you?
Around Christmas is when he came to my house.
Just showed up at the door one day?
Then he got out and he stayed 2 days and then he started acting weird. We got into it.
You gotta be careful who you're hanging out with.
I didn't know the dude. That's where I messed up.
Well, why would you invite somebody to live with you if you don't know the
I didn't
dude?
invite him to live with me. I did not invite him to live with me. I promise you that. He would not leave. He's psycho. If you've seen all the police reports, you would understand what I was dealing with. Like,
Your Honor, I have a voluntary statement written by Miss Spicer in her own handwriting dated 12/23/25 that says, me and my boyfriend were arguing and he threatened to put hands on me. So I ran out of my apartment with my son and then he launched a water at me and hit my son in the leg. Below that says, I do not wish to press charges. I just want to be left alone. If Miss Spicer pressed charges, there would have been a no contact order and Mr. Halliburton would have been precluded from being at the property. He shouldn't have been at the property anyways because he wasn't an approved resident.
Well, I get it. Okay, let's try to fix this for a second. I'm not evicting her because some yokel out there that happened to take over a property left rubbish outside the dumpster. Come on. I'm not doing that. I'm not doing that. Let's figure out how we're getting this young lady back into the unit. So let me do this. Where's the manager of Owner's Management?
I can have him Zoom. No, Your Honor. I expected that we wouldn't reach a resolution today and we would set this for a hearing.
Have him Zoom in. Let me go on and take Ms. Collins. I will Zoom him in and we'll go from there. Have a seat at the table there, Ms. Spicer. Kegler, Hamptons versus Kegler. Tasha Kegler, 260-310. Counsel, your appearance.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Ms. Kegler, your name? Tasha Kegler, I'm going to need you to start your video, unmute, and tell me your name, please.
Okay, good morning, Judge. My name is Tasha Kegler.
Start your video, please. You have to start your video. There you go. There you go. Did you, Ms. Cohen, your appearance?
Carolyn Cohen, appearing on behalf of the plaintiff, Your Honor. We reached a resolution.
Good, give me that.
Okay, we have agreed that there is a total of $2,502.08 owed in rent, $270 late fees for a total of $140, $176.54 in court costs for a total of $2,818.62. Ms. Kegler has agreed to pay $1,409.31 by February the 20th, and the balance of $1,409.31 by February 27th. And she gave me permission to sign her name to this and electronically submit it to the court.
You agree to those terms, Ms. Kegler?
Yes, Your Honor.
All right, so you understand and agree that you owe $28,1862 and that you're going to be required to pay $1,409.31 on the 20th. If you do, the writ date's extended until the 27th, at which point you still got to pay another $1,409.31, correct?
That is correct.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
I understand.
All right. Any questions? And by the way, you gave her permission to sign your name, correct?
Yes, that
You're
is
all-
correct.
You're all set then. Have a great day. Thank you, Ms. Cohen. We'll see you later. I know
Thank you.
everybody's been patient. I was at Woodhaven High at 10 to 8, 5 to 8, and I am taking a 5-minute recess. Everybody stay seated, please.
It's Lakeisha Green. That's a dismissal, Your Honor. We'll sign that.
So that makes it easy to figure out. Well, and it's like the oldest case. That's what can't help but be happy about that. Then I got Roberto Mears.
Yes, Judge.
That one.
More Judge.
Roberto Santana Mears.
And that's another one. Okay.
Stays for the judge.
I was until this morning, Judge, but I do have an objection to lodge, just.
Lodge it. Go ahead. You
Um,
can have lodge those objections anytime.
there was a notice of enhancement that was filed or that I received this morning. Mr. Ham says that it was filed Friday. It didn't.
No,
come
it's
through.
this morning.
Oh, okay. It didn't come through for me until this morning. It's a notice of enhancement. I don't feel like that notice is timely, given that this case is 1,174 days old. It hasn't been alleged, it hasn't been hit in the indictment, and I just received that filing notice this morning. This certainly impacts how I navigate communications with my client about a plea deal versus trial. I think knowing about the intention to seek that enhancement in that way is important for those conversations.
I disagree, Judge. The defendant has been on notice about the offense since its beginning. His prior lawyer was notified at the multiple trial settings that we had about this the prior, and it's been a part of discovery since the beginning. The actual formal notice saying I'm going to use it to enhance was filed today, but the actual knowledge about the prior and what the consequences for it has been in existence since the beginning of this lawyer's representation of this defendant, and well into when this defendant was charged for the offense and when it was initially placed on the trial docket. It's a federal prior. He was sentenced to 36 months. And as I said,
all the documentation and all that's part of the discovery and has been for quite some time.
Judge, if I may, I do have the documentation of it. However, without the formal notice of an enhancement, my assumption is that it's for his ineligibility to receive probation from a jury, not that it's being used for the purpose of enhancement. So I'm not put on notice about that purpose of enhancement or that it's being used for that reason until I'm given that formal notice. It wasn't alleged in the indictment and I didn't receive that formal notice until this morning.
Give me something that shows that. I mean, you know,
If that's going to delay,
it can be the way they are, but you knew he knows, his previous lawyer has known this has been around, by the way, since over 3 years. And so according to the state, his previous lawyer knew that there was an intent to make it some kind of issue at trial, and then I'm sure that information should have been passed on, but the defendant knew. I can't believe his lawyer would have ignored that and said, and refused to inform him. But the question becomes, does a formal piece of paper have to be filed, notwithstanding the knowledge of the parties that there is a prior conviction that can be used, and that the state has tendered to lawyers representing him. And I think you're the third one.
No,
she's the
I'm the
second
second judge. And I believe I've been on since October of last year.
Because, well,
and I believe I stood here on the record and made a statement about this notice previously. Not, in all fairness, she wasn't there, but Mr. Cobb was.
Was the defendant present as well?
Yes. And the record should state that, so if it ever becomes an issue.
It may need to be. You may need to find something. We may need to pour into the record. We have the dates that these court settings were made. So that's the issue that this court's concerned about. Doesn't a piece of writing have to be in there when it was stated in the record with all parties present? Because it's all about supplies, and depending upon how it was presented. I mean, I guess I don't think they just say, and he's got a prior conviction without saying, I intend to use that.
Sure, Judge, but it's about the intention of how it's going to be used.
Yeah, but if it's going to be used, you have to be sure it can be used for all purposes under law. But just find something that says you have to have a formal written motion before that can be used.
The only case law I'm aware of is that it has to be done prior to the commencement of trial, Judge. And we've done that satisfactorily today.
Sometimes that puts a defense attorney in a bad spot. Because what this jumps up from in this case, of course, is from 2 to 20 to life.
And I understand that Mr. Cogman had received notice, but in order for me to protect myself, for me to choose to, these are objections that I have to lodge.
Okay. But all of that, I know that. But according to what he's stating, the defendant was present. The defendant knows, and whatever the previous attorneys' actions were, they should have been passed on.
And I believe
one way or the other, but the defendant knows it.
I believe I have emails with the prior counsel of the intention as well, Judge.
I think you need to get what you can.
Yes, sir.
On that.
Yes, sir.
In fact, I even say there's a motion to withdraw that I even denied.
Yes, I think that was around
Because of this.
Judge Reagan found these to. I don't want to lose them. It's the notice acknowledgement form and the jury.
But it's there's no way that it can be almost 1,200 days old and still people are declaring surprise. I know there may not have been a formal action taken, but get what you can of supplemental information, so I can make the record, but it's old and needs to be all
Stated, ready.
I hear Judge.
Oh, no, thank you.
Thank you.
John, on airplane pro?
State law motion to dismiss.
Was that done automatically?
Thanks. I don't know. I think we got you.
I don't see anything wrong. Daniel Rollins. Daniel Rollins. Maybe. Does he need to be up here?
I have one issue.
Yeah. You just won. I've known you for a long
One
time.
is Monday position. Well,
That's an understatement.
I'm not talking,
Go ahead. What's up?
of course, we're here and subject to
Yes.
state needs. I think there's some things they want to address with the court.
Go ahead. Hit me with your best shots.
We have an issue with the monitor for alcohol.
You are for or against it?
I'm kind of like straddle like
Okay. There's something about it that's not being, it is not working correctly.
We've had a long history of problems with the ankle monitor. As a matter of fact, we've had numerous hearings in front of this court. So in an abundance of caution, we knocked down drag out fights. My client has now had 2 monitors. Just as a backup because of the unreliability of the one on his ankle.
What's unreliable with that?
Well,
like I forgot what we talked about before.
Yeah, they're given, our position was given false positives and bringing back, but it's causing a medical problem now. And so I was requesting that.
What's your alternative plan?
To take that off and let him, he has a handheld time that he has to, so how often?
4 times a day.
4 times a day. And he's been on a monitor for how many months now? No.
What's the whole, the whole purpose of it is what? What was the whole purpose?
The whole purpose of one was based on the charge that he doesn't do it. He's been complying with it, but the one that's on his ankle is causing a medical condition now, and he can show the court.
And that just tests for alcohol in his system.
That's all he really was.
We don't have one to show where he is, like a GPS, like he's
never
driving around when he
Never
could be.
Never happened.
Okay, something though, we don't, neither of us want to be on the front page with the headline, who's to blame if he's out there driving.
That's never been an issue.
Intoxicated. It never is until it becomes. And then everybody points to everybody. And here it is, we're talking about intoxication manslaughter. Shame on what happens next. If something bad happens, there will be an accounting, a rendering. Somebody will be blamed, or 2 or 3. It's not going to be me. So what do we come up with?
Well,
other than just his good word.
I'm not asking for no monitor. What I'm asking for is because he has another monitor that has been following him over the last 6 months with not any, matter of fact, it's a more detailed monitor.
with no violations.
I just don't understand what the difference is between those two.
Well, it's causing a medical, it's.
I mean, but what's the, no,
infected.
what does it, what does it provide to the people who are
It's
rendering
going up 2 digits. in
the
reference-
supervision?
Well,
So we, I mean, it needs to be supervised, that's all.
Does that one have a camera on it to know that it's him testing?
Yes, ma'am.
So how does the other one that you're talking about, how does that work?
The one that I went out and got on my own tests out 3 decimal places and has a camera showing me using it. The ankle monitor does not.
Well, it's connected to your ankle. So who is monitoring that then?
Johnny's.
Who has been used forever.
yeah, but the one on the ankle is causing infection. Medically now.
Well, what is, have you gotten to a doctor or something about, I think they can put something that, can't they put something between the skin and the device? No?
No, because then you don't get the sweat or the.
Well, so can y'all try to work that out, or if there's something that
I
y'all
will
can
show you
reach?
if you want to see his ankle.
No, no, I'm talking about working it out.
Oh, Judge, I don't have any objections to doing this the other way. I can see what he's talking about.
Okay.
As long as,
Point,
yes.
obviously. Go ahead.
And so
But it
the
needs to get
order
done.
is that we will get his documents to you to switch, remove that
All right.
and keep them on.
Okay. What are you doing about preventing an infection?
There's no
Yeah, have you seen the
product
doctor?
that I know. This monitor, sir, this monitors external things, and there's nothing topical I know of that I can use.
Well, you talk, I know you know, but what does your doctor know? Yeah,
I have not talked to a physician
Be
about it,
careful
but I
about
talked
an
to the
infection.
monitoring service.
Yeah, be careful about that. Especially there. I mean, you know, feet come in handy
Yes, sir.
in life. Okay. All right, well, yeah, request is granted.
Thank you. I'll submit an order today.
Okay, that's done. What's next? Y'all ready for trial otherwise?
We are, but
What's they say?
I think the state would like a special setting because of the circumstances.
Because of the circumstances and having to communicate with this family and the death of their loved one.
Why don't y'all get together this morning and give me a date for 2?
Yes,
And
sir.
then that will be set this morning.
Yes,
Okay?
Thank you, Your Honor.
Before y'all leave. Thank you. Bruce Calhoun?
He's here, Your Honor.
That's nice. What are we gonna do about that?
Look,
What are we doing?
I made it.
It's a
Made it
1,000 days old.
of the state's offer. I just want to I just put on record, Judge, the state had offered 2 years deferred adjudication probation.
How much?
10 years deferred. 10 deferred.
Which, as we all know, can be shortened to 1/3 of that if they do well.
And I conveyed that to Mr. Calhoun, and what was your response?
What do you say? I didn't understand. Oh, okay. Well, we're gonna go over time. Let's see. That'll be, y'all ready?
We can be ready.
Yeah.
It was tonight's.
Also, we've got another court that we're going to send to. We can send somebody on bond, so that's good. I can get 2 done.
I think everybody on this docket is on bond, Your Honor.
Good. Yeah. That's, okay, y'all stand by. I'm gonna name him in a second. Dagan Rutz?
He's here too.
Come on. It's looked down, yeah. What are we doing on this? Are you kidding? We're trying this one too?
We're ready, Judge.
Okay.
Give this to my please. Shouldn't put that. Those are the plea rejection forms. Kind of, yeah.
Absolutely.
Okay.
Okay. You tell, I mean, you did.
What was the offer on this?
Right. This is another case where the state had offered deferred adjudication
And did you want to defer or you still want trial? So that's the concept.
Okay. You understand if you happen to be convicted of this in a jury trial, deferred or unadjudicated probation is not something a jury is allowed to give. In a jury trial, you get convicted and the conviction is forever. Okay. You haven't by any chance had contact with the victim in this, right?
No.
Because that would be catastrophe for anybody.
No, sir. Just an individual that I did the purchase through on the side by side. I have the two Facebook or messengers. So he's actually doing time with me right now. It is from Jasper.
Okay. Okay. All right. And we're going to try to find you a trial. Alicia Jones. Alicia Jones, Dustin.
Yeah, today.
Donald Kelly.
Your Honor. Right.
Oh, who's the lawyer on this one? I think it's Miss Moore.
It's Miss Moore. Yeah, I believe it. You'll see that.
What? We've never tried a failure to register in 20 years. So
we tried one.
What's the deal on this?
Yeah, I've tried one before. I've actually tried two of these.
How did that other one end up? I think it was a conviction, wasn't it? Yeah, I do remember now. It was like maybe a year or two ago.
Yeah.
But it's very odd.
Yeah.
What's okay.
Yeah.
Trying to tell you to register. Okay. This is real simple. These are real simplified. Is he eligible for probation?
No, because of the offense.
Prior conviction. Okay, he knows that.
Yes, sir.
All right. So no,
I wouldn't just say
you don't need to talk about it. It's going to move forward, and it'll go somewhere today. Willie Dumas.
Ready, Your Honor.
Complete.
We have to keep bringing down.
Willie Dumas, where are you?
I'm here, sir.
Well, you're loaded today with all kind of hardware.
Oh.
What is all that? What's that on your lapel?
Oh, it's
Or no, the lapel. There we go.
Okay.
That one. Yes, sir. What is that?
It's a flower with diamonds around it.
What is it? What does it represent?
Oh, no, I
flower with
just
diamonds.
coat up.
Oh, well, that's a nice thing. So it certainly got my attention, I'll tell you.
Well, he does a lot of church.
Sir,
Yeah.
He does
is it for the church? Yeah. Okay. That's it.
Yeah.
You're Willie Dumas Senior, correct, sir?
Yes, sir. Yes.
Where's
And you were here with Mr. Lang, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, Your Honor.
Looks like we're only going on paragraph 1 here, because there's a prior conviction that is not being asserted in this case at this time. In summary, and you were Willie Eugene Dumas Sr.
Yes, sir.
And Mr. Dumas, this indictment states in summary that on or about December 2nd, 2023, in Jefferson County, Texas, you committed the third-degree felony of theft from an elderly individual. It's like a purse. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years, fined $500. Is there any restitution here?
No, Your Honor.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or
Guilty,
not
sir.
guilty? Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will
Yes, sir.
and because you are guilty of this.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered?
No objection.
Without objection admitted. Will state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read here. You've read it. You were guilty of the crime charged and any lesser included offenses. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, the state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived here?
It is by defense.
Anything to add by either party?
Nothing.
I will follow this agreement and make the findings that you are pleading guilty voluntarily. You are mentally competent to do so. You do appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of theft from elderly person. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You're going to get placed on regular probation for 10 years. To do well, it will be shortened over.
No problem. Yes, sir.
There will be other terms and conditions of probation, which are normal and customary for this type of offense. There'll be a fine of $500 also imposed here.
This is about the.
And among other conditions of probation, you must successfully complete a theft prevention program. It's a good program for everybody. Thing. But it's normal and customary for this type of offense. Here are the papers. Please see the probation office and you begin. Good luck. Yes, sir. I've got Mr.
Except.
Christian Simeon.
Right here, yeah.
And
You just sign the paper.
okay, hold on. Let me go through the rest of this so we can. Okay. No, what do you need?
Just resell.
Okay, how much time?
Just
He's trying to get me better.
4 weeks.
It's all good.
That's
All right, done. Yeah, get that. Yes, sir. You bet. The best to your family. Yeah. Okay.
Yes.
Your Honor, the state is not going to be ready on this one. We're going to need more time. There's multiple witnesses. Some of them are out of state.
Yeah. Today.
Right.
We would ask for a reset to the trial
How
docket.
much?
4 weeks.
It's sir. 4 weeks.
Yeah, where's?
No, he's only, he's in traffic.
Yeah, but he still needs to be here, get here.
Yeah, I understand.
All right. When he gets here, let me know so I can say hello to him. You telling me what's my ETA? I couldn't tell you because I could go at any moment.
You and me both. But yes, I'll wait for them.
Estimated time of essential. Okay.
Thank you.
Robert Glasper.
No.
Robert Glasper. Robert Glasper. Did you see him?
I'm looking.
24 CR 1032 is called Robert Glasper. There is no answer here in the courtroom. I asked the bailiff to call into the hall for Robert Glasper. Well, that guy there, yeah, that didn't, that wouldn't, that guy did not recognize that name. Robert Glasper. He is a transient. That's not him.
There's no response, Your Honor.
No response to the name called here in the courtroom. No response to the name called into the hall. This looks like a state jail felony with 2 prior convictions on different dates of second-degree felony. So I guess this is a state jail felony punished as though we're second degree. What's his bond?
7,000.
Bond is revoked. The warrant is issued for his arrest. This is trial docket. So bond is $50,000.
I'll stick around to this.
And he must have a GPS.
Okay, we're here today because your probation officer, Mr. Henry, has requested that you be terminated from supervision. Anything else for probation, Jack?
Other than what was sent in the email, I would continue to state that we have not had a single issue with this supervision since he had started back in March of 2021. He has continuously tested negative on all substance tests and completed all the court's orders as requested. And as sent in the email, it provided a letter that he wanted to provide to the court for the victim.
Okay. Anything from the prosecutor's office or victim?
We have reached out to the victim about this request. We have not heard back with regard to our request for defer this work on appropriate.
Okay, Mr. Rush, anything, sir?
Just, I have this letter for you, sir. I just would like you to hear, just take
Sure.
consideration.
Sure.
I'm writing this letter today as I want to reflect on where I was in the beginning of this case, where I am now. Also, I want to take the time to make a statement that to the victim and her family, I am deeply sorry for what I have done. I hope she is able to recover and move forward with her life, and for the trauma that I have caused towards the victim, I cannot imagine what she has gone through mentally, physically, because now I have younger children myself. I have 5 and 4-year-old as well. What was that? I apologize. I've done everything she must have experienced, and how much it has affected her and her family. Out of pocket costs, I can only imagine. And you ordered me to do the treatment, and I believe that was the best decision that anyone's ever done for me. Excuse me. The treatment has helped me mentally, physically, because there was so much I have never even known about the situation, and I put myself in knowing that I understand everything from the treatment. I know for 1,000% I was in the wrong. I blame the victim all for what, for her coming forward or making the decision to talk to her parents or the police officers. So I understand what I've done. Yes, I only spent 5 days in jail, but me reflecting on that, knowing that I lost half of my family because of what I've done. So I totally understand. I've lost my other part of my family. But I honestly should have been there longer. Yeah, I was only in there for 5 days, but I deserve to be in there longer. But I thought about how much trauma and damage I must have caused the victim and her family. I wish I could take back what I have done. I'm done with my treatment. I have been talking to Orion, which was the guy who helped me with my treatment. The program, even after I even completed it, I still talk to him now and then just to talk about life to make sure I'm on a positive track. I still keep in touch with him. I do some community service, working at the Valley Thrift Store near me in Laughlin. They try to help out as much as I possibly can.
sometimes the programs on the weekends when I'm available. I even help the elderly when I can, because my grandmother, after this case went through and everything, she was there by my side. She recently passed, and that was like my anchor, but she kept me focused. I was on house arrest with her for 6 months, and me and her were really, really close. So she helped me through everything. Whenever I have a chance, I could go back to my community. I have changed. I'm a different person than before, and there aren't enough apologies in the world for what I have done. The latest, I've wanted to say thank you, Judge, for giving me the opportunity to enter that program, knowing what I know then and what I know now. I had no idea what I've done, and if I could go back and change it, I would change it in a heartbeat. And I can't imagine the old me and how I acted. And like I said, I deeply am sorry, and I am a different person now that I am then.
Well, Mr. Rush, I appreciate that letter. Mr. Hartman, do you want a copy of that letter for the sent to the victim or not?
We can, if he wants us to do that.
Would you like us? Yeah,
absolutely.
I mean, because for you to come in here today to and have, okay, you have that. He has a copy of it. To have put that thought and time into that it's unusual, number one, but it does seem to come from a place of sincerity, and I appreciate that. The court is going to grant the request to terminate you from supervision. You do understand that this does not terminate your registration requirements.
Yes, sir.
Those continue on. I have no control over that.
Yes, sir.
All right. Mr. Hartman, is there anything else?
No, Your Honor. Thank you.
All right, Mr. Rush, I'm going to terminate your supervision. Congratulations and well done.
Thank you, sir. I appreciate you.
Case number 25CR42989, the state of Ohio versus Chelsea Teagarden. Ms. Teagarden is before the court with her counsel, Mr. Kidd, Ms. Tranter, on behalf of the state of Ohio. Ms. Tranter.
Your Honor, my understanding is that Ms. Teagarden is going to be changing her plea to guilty to one count of unauthorized use of a vehicle, felony in the 5th degree.
Mr. Kidd, is that accurate?
It is, Your Honor.
All right, Ms. Teagarden, they tell me you're going to change your plea to guilty to the one count of the indictment. Before we get to your change of plea, I am required to go over some things with you, okay?
Yes, sir.
How old are you?
I'm 35.
How far did you go in school?
I'm almost graduated. I'm in school. I'm finishing my high school diploma.
Okay, can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Kidd?
Yes, he's been pretty awesome.
Are you currently under the influence of any drugs or alcohol?
Oh, no, sir.
Do you take any medication that interferes with your ability to understand what's going on?
No, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Mr. Kidd?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of unauthorized use of a motor vehicle as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison, upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of Mr. Kidd, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
All right, Ms. Tranter.
Between the times of April 15th, 2025 through August 22nd of 2025, Warren County, State of Ohio defendant Chelsea Teagarden did knowingly use or operate a motor vehicle without consent of the owner and did keep possession of it for more than 48 hours.
Mr. Kidd, anything on those facts?
No, Your Honor.
Ms. Teagarden, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, those rights we discussed.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and the court will accept your plea of guilty, and based upon the statement of facts and your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation. Ms. Teagarden, we'll come back in a few weeks and do sentencing at that time. Mr. Kidd, you wish to be heard?
Yes, Your Honor. Ms. Teagarden would very much like another opportunity to be out on bond. She would be more than happy to have an electronic monitor on her. She knows that she had a situation last time, that did cause her not to come to court and a case initially being issued. The facts this time are far more significant in many ways. She's now entered a guilty plea to a felony, not an ILC. In addition to that, her biggest concern is she has a minor child, a 16-year-old, who is now in custody of Butler County Detention Center on significant charges. She would love to be able to be present at his detention hearing, which is coming up on February 18th. There could perhaps be some CPS issues as well that will be involved in that. And she wants to be there as his mother throughout all of this. So not only does she have the consequence of not showing up to court, being very significant in this case, but also she needs to maintain her sobriety. She needs to show up to all court appearances, all hearings, for the purpose of her maintaining custody of her son, in theory. So that's what we would ask. She does have a place to live in Middletown. Actually, it's in the Warren County part of Middletown. It's with her brother. That's 2434 Brookview. Again, Your Honor, we understand that she did not do well first time around, but she assures me she would do much better this
I
time.
promise.
And I don't know if she has anything else she wants to say to the court, but that would be our ask.
Ms. Teagarden, in September, you were bound over from the Mason Municipal Court, September 3rd, 2025. You were granted an OR bond by Judge Batchy with pretrial supervision of this court. You were ordered, you signed a contract, you signed a document on September the 2nd stating that you would report to court services in this building. You did not report. An order to report was sent to you on September 18th for you to report on September 18th. And again, you failed to report for court services. You were arrested on November the 6th. You were arraigned on November 7th. I then released you again on November the 13th. And once again, you were ordered to, listen, there is absolutely nothing that you can say that changes any of these facts.
Yes, sir.
Once again, you were released from the jail and ordered to report to court services. And guess what? You didn't report, right?
Yes.
So here we are twice now. You have been ordered to report to court services to be supervised just to make sure that you're complying with the conditions of your bond, and you don't do it. How simple is that?
I know, I'm sorry. I really do apologize.
All right, I'm going to give you one more chance, and I'm going to tell you right now, I will release you today on your own recognizance once again with pretrial supervision. The moment you walk out of that jail, you are to come to this building.
Yes,
You understand
sir.
that?
Yes,
And if
sir.
you don't report, I will issue a warrant for your arrest, and you will remain in jail until this case is finished.
Yes, sir.
Do we understand each other?
Yes, sir. I promise. I'll be
You
there.
leave the jail, it's right across the parking lot. You walk over to this building and you report back to court services.
Yes, sir. Thank you
All
so
right, Ms.
much.
Tranter, is there anything else?
No, sir.
Mr. Kidd?
Thank you, Your
All
Honor.
right, that's it.
Can we talk about it? Thank
Let me
you.
see.
Thank you.
See ya.
We're going to do a pre-sentence investigation, set this for sentencing in about 30 days. Is that all correct?
Yes, Your Honor.
That is correct. My understanding was there'd be a waiver of indictment, any defects in service, since this is an amendment of the original charge. It's a one-count indictment.
That is correctly stated, Your Honor.
All right, Mr. DeFada, how old are you?
31,
How far did you go in school?
11th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes, sir.
What are you taking?
I'm prescribed Suboxone.
Are you taking anything that would, excuse me, are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
If you enter a plea of guilty to this charge, you're going to agree to restitution in the amount of $298.88 and to a no contact order. I'm going to do a pre-sentence investigation. We're going to come back here in about 30 days for sentencing. I really don't know if additional jail time is warranted on this case. It might be, Mr. DeFada, but I don't know because the facts are a little, shall we say, convoluted. So other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Berger before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of unauthorized use of a motor vehicle, which is amended to be a first-degree misdemeanor. It's punishable by up to 180 days in jail and a $1,000 fine. Your rights really haven't changed that much since we went back over them a few years ago. Still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to waive any defects associated with the amendment to this charge. You're going to admit that you did it, and we're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, was the state able to confer with the victim prior to the amendment of the charge?
Yes, Your Honor, and the victim is in agreement with the way we are proceeding with the plea today.
All right, what's the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations and the indictment as amended, to unauthorized use of a motor vehicle misdemeanor of the first degree, that on or about September 12th of 2025 in South Lebanon, Warren County, Ohio, Michael DeFada exerted control over the victim's vehicle without her consent at the time and beyond the scope of their agreement.
Anything on those facts, Mr. Borger?
Nothing on those facts, Your Honor.
Mr. DeFada, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
You understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. You need to go back down to pretrial services, fill out the paperwork for the PSI. Anything else for today?
No, Your Honor. Thank you.
No, Your Honor.
All right, that's all.
Thank you.
Ms. Kuroko, we're just going to leave the Zoom link running until 1 o'clock, right?
Yes.
Yeah, David Leckner. Yes, Your Honor. David Leckner on behalf of Owners Management.
Ms. Spicer.
Thank you.
Where's the manager?
We have
Oh, there she
Crystal
is.
Larson. Yes.
All right, ma'am, your name?
Crystal Larson.
Your name?
Justice Spicer.
I want to make sure she gets entry into the property again. The guy has vacated the property, she tells me. He has no clothes. He left the place. He doesn't have a key, right? He doesn't have a key. So can we just, to begin with, change the locks and get her back into the property?
Your Honor, I think we're glossing over the fact that she had a unapproved resident for over 2 months, where the lease calls for people that aren't on the lease, that are unapproved visitors, can only be there for 1 month over the course of a year and not for more than 14 days straight.
What I'm telling you is, I'm going to set this for a hearing.
Okay, understood.
I want her to be able to get back into the property in the interim without fear of this guy coming back. I'm not evicting somebody over rubbish. I'm telling you, let's not be silly. He's not there anymore. I don't mind telling you, you're probably going to lose that. But young lady, listen to me. I'll give you your hearing, Mr. Leckner. You can't fail to comply with the rules. No, I don't think you do. That you have rules. If you want to make your own rules, buy a house out in a farm where nobody's 17 miles from you. You can yell and scream, play music as loud as you want, and do whatever else you want. You can bring in 13 people to live with you if you want. You can bring dogs and cats and goats for all I care. You can't let people in there. You can't let people in there. Ms. Larson, are you going to assist her? Can you change the lock so this guy doesn't come back that seems to be maybe somebody that's not going to join the church choir anytime soon?
Yes, Your Honor, we can do that.
Well, let's do that and let's set it for hearing, but
That guy, the one illegal.
you guys are telling me, Mr. Leckner, this was over garbage is what you first said, right?
Well, this violation from December 29th, yes, was over garbage that was not put into the dumpster, but was left outside the dumpster in violation of the lease. But since then, I've become aware in preparing for today's hearing that Ms. Spicer has had an unapproved guest for over 2 months in the unit.
Well, she didn't say that to me. Sounds like he was more of an uninvited guest after the initial time, but why you would invite him there, I don't know.
Well, according to the police,
I invited him to come over his company because I thought we were allowed to have guests, and he got crazy and wouldn't leave my house. I didn't know what.
You got to be careful who you're hanging with. You know what I mean? I was just at a court to school program telling kids that are 17 and 18 and 16 the very thing I'm telling you. How old are you?
23.
You're 23. You're far past the age at which you should have figured this out. You want to hang out with the bums, they're gonna treat you like garbage. You follow me? Get her back in there. I'll set this for hearing. If you're gonna bring up something else besides garbage, you might win, but I don't think so. I'll bring it. I'll set this up for hearing in a month. We'll see how everything's going. I'm gonna be gone. Why don't you give me the 16th of March, Jennifer?
Okay, Your Honor.
So can we make that an afternoon hearing, Your Honor?
Yeah, we'll do that at 1.
Thank you.
Okay? 1 o'clock. Thank you.
Thank you, Your Honor.
Ma'am, comply with rules. You have rules. No, you're not trying.
Just come get me when you're ready.
If you're trying or not. But you got to comply with the rules or else you're just inviting them to bug you. You know? You just are.
One of the problems are where I think I should be doing.
Well, stop inviting people over that are the type that you just described to me.
I agree.
All right, good luck. You
And
gotta
Judge, that's
grow up,
March
young-
16th, correct?
Yeah, March 16th at 1. You
Okay.
got to grow up a little, young lady. Hamptons versus Aaron Kennedy, 2600322. Kennedy.
Morning, Your
Good
Honor.
morning.
Robert Visconti, P61756 for the plaintiff.
Is Harrison Kennedy or Aaron Kennedy here?
Yes, Aaron Kennedy. Good morning.
Did you listen to and understand the rights, ma'am?
Yes.
Do you wish to speak to a lawyer or apply for funding?
So applying for funding, yes.
Is that what you're going to do?
Yes.
All right, that buys you 2 weeks. You have to submit your application for funding to this court within 5 days. Do you understand that? By the
Yes.
end of the week, okay? We're going to adjourn this 2 weeks to what, the 23rd, is it, Jennifer?
Yes, Your Honor.
At,
We will do that at 10 o'clock.
10 a.m. Okay, ma'am?
And how do I submit it to the court when I
You
apply?
bring it up here. You should bring it up here, okay?
Okay. All right, thank you.
Good luck. Thanks. Hamptons versus Cynthia Bazzi and Jalen Marzetti, 2600323.
Robert Visconti for the plaintiff.
I don't see them out here. Did you talk
Your
to
Honor, I
them?
didn't have them check in.
Okay, so you paid for a second mailing and we'll take a default if you want.
Thanks, Judge. I move the court for default judgment for possession. Rent to retain is $1,343.43. They actually paid all of their court costs with the exception of the statutory attorney fee. So the court costs will only be $75 for a total redemptive amount of $1,418.43. Writ to issue after the 19th, please.
Okay. You said 14/18/93, right?
43.
43, I'm sorry. Default judgment will enter. Writ date will be the 19th. The amount to be saved to save it is $1,418.43. Hamptons versus Derek Gibson, 2600326. Derek Gibson.
Robert Visconti for the plaintiff. We'll move for dismissal of that one, Judge.
Case dismissed. Motion to plaintiff. I'm not sure why Mr. Landau's here. Does he have something else with me, you guys? I'll check that in a second.
Yes, he does, Your Honor.
Hamptons versus Tepe Broadnax, 2600327. Broadnax, where are you? Start your video, please, Tepe Broadnax, and tell me your name.
Trying to figure it out. I'm here.
All right.
Tanae Broadnet.
All right. Did you listen to and understand the rights?
Yeah.
Do you wish to talk to a lawyer or will you be applying for funding?
No.
All right. Counsel, your appearance.
Robert Visconti for the plaintiff. We have a proposed consent judgment, Judge.
Good enough.
Rent to retain is $2,251.77. Court costs are $176.54 for a total redemptive amount of $2,428.31. Possession only with a writ to issue after the 27th, if not paid.
All right. You're not giving me the late fees. How much were the late fees per month?
Your Honor, the total late charge is $140. That's $70 a month for 2 months.
Okay. All right. Good enough. Writ date will be on the 19th. I'm sorry. What day did you say? Writ date 19th?
We extended to the 27th, Judge.
All right, ma'am. Do you understand and agree to those terms? 242831 with the understanding you have to pay that by the 27th of February or vacate. And if you don't do either one of those, you'll be evicted.
Yes.
Okay. Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
Any questions?
No.
All right. 242831 by the 27th. Good luck. Hamptons versus Gerard and Rosalind Grimes, 2600328.
Robert Visconti for plaintiff.
Sir, your name?
Gerard, right?
Come on up to the podium. Did you listen to and understand the rights?
Yes.
Where's Rosalind?
She's on Zoom.
Where's Rosalind?
She's on Zoom.
Rosalind, you have to state your name and start your video.
Rosalind Grimes.
Start your video.
Okay. Hello?
All right. Did you listen to and understand the rights?
Yes.
Did you speak with them, Mr. Visconti?
So I spoke with Rosalind. I didn't speak with Gerard.
I agree with whatever she said. I agree.
Did you guys reach a consent judgment?
I reached a consent judgment with Rosalind. She may have conveyed the terms to Mr. Grimes.
Why don't you give me the terms of the consent? He says he's going to agree with whatever she did, but go ahead.
So Your Honor, rent retains $1,445. That includes $170 late fee. We have $221.43 in court costs for a total of $1,666.43. Possession only, and we've agreed to extend the writ date in this matter to 2/27.
All right. Do you agree to those terms, ma'am?
Yes.
You agree that you owe $1,666.43?
Yes.
You understand the writ date will be on February the 27th, you said, right, counsel?
Correct.
Yes, I do.
Do you agree to those terms?
Yes.
You agree that you owe $1,666.43 with the understanding you have until February 27th to pay?
Yes.
You wish to enter into a consent judgment with respect to that?
No.
You don't?
Yes. I mean, yes. I agree.
Okay. I just want to make sure. I don't want to trick you or anything. Is that what you want to do? Is enter into a judgment with this lawyer here?
Yes.
And he's going to give you an extra 8 days, it looks like, to pay. Do you agree to that?
Yes.
Does he have your permission to sign your name to a proposed consent judgment?
Yes.
Ms. Grimes, does Mr. Visconti have your permission to sign your name to that proposed consent judgment?
Yes.
I want you both to understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal. Do you understand that, Ms. Grimes?
Yes, I do.
Mr. Grimes?
Yes.
Do you have any questions for me, sir?
No.
Ma'am?
No.
Question? All right, you're all set. Writ date will be the 27th. He's going to sign your name. Just make sure you get the money into him by then, okay? Okay. Thank you both.
Thank you.
Have a good day.
You too. Thank you.
Versus Tansha Huggins.
Robert Visconti for plaintiff.
260. Is she here, Tanya Huggins?
She is. She just
Gotcha.
got muted.
Okay, ma'am, your name?
Tanisha Huggins.
All right, is this going to be a consent counsel?
Yes, Your Honor, it is.
All right. You can go ahead and give me the terms.
So, Your Honor, rent retained is $2,298.08, inclusive of $140 in late fees. That's $270 per month. We have court costs of $176.54 for a total of $2,474.62. Possession only, and we've agreed to extend the writ date in this matter to 2/27.
Ma'am, do you agree that you owe that amount?
Yes, I do.
Do you wish to enter into a consent judgment whereby you either have to pay that amount or vacate by the 27th of February?
Yes, right. That means I do want to pay for it, correct?
Yeah, you can pay for it, but if you don't pay, you have to leave. You understand that?
Yes, I understand. I was just making sure that I was consenting to the correct thing.
Yep, and you have 3 business days to come in here and fill out a motion to set aside this judgment if you don't like it or don't understand it. You have 10 days to appeal since you're unrepresented by a lawyer. Do you understand that?
Yes, I do.
Do you have any questions?
No, I do not.
I wish you well.
Thank
and
you
he has
so
your
much.
permission to sign your name, correct?
Yes, he does.
Good luck, ma'am. I wish you well. Hamptons versus Joanna Taylor, 2600330.
Robert Visconti for plaintiff.
Ma'am, your name?
Jelana Taylor.
Did you listen to and understand the rights on the video?
Yes.
Did you two talk, Mr. Visconti?
We did. We have a proposed consent judgment, Judge.
Okay, go ahead with the terms.
Your Honor, rent retains $2,539.15. That includes two $70 late fees. We have $176.54 in court costs for a total of $2,715.69. Judgment for possession only, with a writ to issue after February 27th, if not paid in full.
Ma'am, do you agree
Yes.
to those terms?
Yes.
All right, so you understand you have until February 27th to pay that total amount, $2,715.69. If you don't pay that amount by that date, you have to vacate. If you don't do either one of those things, you're going to be evicted. Do you understand that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal as well. Do you understand that?
Yes.
Any questions?
No.
And he has your permission to sign your name to this proposed consent judgment?
Yes.
You're all set, ma'am. Good luck. Thank you.
Thank you.
Hamptons versus Brandy Moore, 2600331.
Robert Visconti for plaintiff.
Hi, I'm
Ms. Moore, you have to start your video and state your name.
one moment. Okay,
There you go. Your name?
Brandy Moore.
Did you listen to and understand the rights?
Yes, I did.
Did you two talk, counsel?
We did, Judge, and we have a proposed consent judgment.
Okay, go ahead.
So rent to retain is $1,739.15. That does include two $70 late fees. Court costs are $176.54. Total redemptive amounts $1,915.69. Judgment for possession only, with a writ to issue after the 27th, if not paid in full.
Ma'am,
Yes.
do you agree that you owe that amount? And do you understand that you have to pay that amount or vacate by the 27th? If you don't do either one of those things, you're going to be evicted. You understand that?
Yes, I understand.
And since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You also have 10 days to appeal this. Do you understand that?
Yes, I do.
All right. Any questions?
No, they received my $800 payment, right? Back on the end of January. I just want to confirm that. I didn't ask that.
Yeah, you've been given credit for that.
Okay, perfect.
All
Okay.
right.
No
So
further
the date will be the
questions.
27th, and he has your permission to sign your name, right?
Yes.
You're all set. Good luck. 1915-69 by the 27th. Best of luck. Tierra
Okay.
Huff, Hamptons versus Tierra Huff, 2600332.
Robert Visconti for plaintiff.
Ms. Huff,
Hello.
your name.
Yes, Tierra Huff.
Did you listen to and understand the rights on the video?
Yes, sir.
Did you two talk and resolve this, Mr. Visconti?
Yes, Judge, we have a proposed consent judgment.
Okay.
Judgment reflects a rental arrearage of $2,468.62, and that does include 2 late fees of $70 apiece. Our court costs are $176.54 for a total redemptive amount of $2,645.16. Judgment for possession only, with an order of eviction to issue if not paid in full by February 23rd.
Did you say 246416?
No. The total, Your Honor, is $2,645.16. 2645.16.
Thank you. I'm sorry.
It's
Ma'am, do
okay.
you agree that you owe that amount? And yes?
Yes.
And you understand you have until, was this writ date the 26th, 7th as well?
23rd, Judge.
And you have until February 23rd to pay that. Do you understand that, ma'am?
Yes, sir.
And since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
Questions? Any questions?
No question. No question.
And he has your permission to sign your name to this proposed consent judgment?
Yes.
Consent judgment will enter 264516, writ date February 23rd, Hamptons versus Amber Abdullah, 2600334. Is Amber Abdullah?
We'll move for
No, Your Honor,
dismissal of that
defendant
one,
has not
Judge.
checked in with us.
Oh, you move for dismissal?
I do. Thank you, Judge.
Case dismissed motion of the plaintiff, Hamptons versus Reuben Plummer Jr., 2600335. Reuben Plummer, state your name.
Reuben Plummer Jr.
Good morning, Mr. Plummer. Did you listen to and understand the rights?
Yes.
Any resolution, Mr. Visconti?
Your Honor, Mr. Plummer indicated to me that he does wish to seek rental assistance, and as such, I believe he's entitled to an adjournment 2 weeks out.
Okay, sir. So I'm going to adjourn this. You have 5 business days to come in here and fill out a motion. I'm sorry, to provide us with proof that you've applied for funding. This will give you 2 more weeks. So I'm going to adjourn the hearing to February the 23rd. Is this going to
10
be
a.m.
at 10 a.m.?
Yes, Your Honor.
And you have to bring in your proof that you've applied for funding within 5 days here, okay? By the end of the week, all right?
Okay.
Good luck. Thank you.
Thank you.
Autumn Williams, Hamptons versus Autumn Williams, 2600336. Autumn Williams.
Robert Visconti for plaintiff.
Come on up to the podium, ma'am. Did you listen to and understand the rights?
Yes.
Did you speak to her?
We did.
All right. Is there a consent?
Yes, Your Honor, there is.
All right.
Rent to retain in this case is $2,312.58, and that does include 2 $70 late fees. We have court costs of $176.54 for a grand total of $2,490.12. Judgment for possession only with a writ to issue after February 27th, if not paid in full by that date.
You agree to those terms, ma'am? So you understand you have 3 business days to come in here and fill out a motion to set aside the judgment since you're unrepresented by a lawyer. I can't hear you.
Yes.
And you also have 10 days to appeal. Do you understand that?
To appeal?
Yeah.
What does that mean?
If you wanted to appeal some irregularity in the proceeding here, you'd have 10 days to file that. I have to tell you that. Okay, do you understand that? You got to keep your voice up.
Yes.
Counsel, did you say the writ date was the 26th or 7th?
7th, Your Honor.
And you understand you have to pay this amount by the 27th or vacate?
Yes.
You have 3 business days, like I said, to fill out a motion, set aside the judgment. I'm going to enter a judgment. Does he have your permission to sign your name to this proposed consent judgment? Does he?
Yes.
Okay, you're all set, Ms. Williams. Just make sure you pay that by that date, okay? Thank you. Hamptons versus Adrian Schaefer. It looks like I don't know if that's a misspelling, Candace or Cadis Crosby Bulware and Stephen Moultrie, 2600354.
Robert Visconti for plaintiff.
Ms. Schaefer, your name?
Adrian Schaefer.
Where's Candace Crosby Bulware or Cadis?
Oh, they're both working right now, so they're not on the Zoom right now.
Did you talk to Ms. Schaefer?
I did, Your Honor. We have a proposed resolution.
A consent judgment?
Yes, sir.
It'll have to be a default versus the other 2 defendants. You can go ahead.
Thank you, Judge. Yes, the judgment would reflect a rental rearage of $2,650. That it does include 2 $70 late fees. Our court costs are $266.32 for a grand total of $2,916.32. Judgment for possession only with an order of eviction to issue after February 27th, if not paid in full by that date.
Ma'am, do you agree to those terms?
Yes.
Does he have your permission to sign your name to a proposed consent judgment calling for you to pay that amount, $2,916.32, right? And with a writ date of February 27th?
Yes, he does.
And you understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, I do.
All right, so this will be a default against the Crosby, Bulware, and Moultrie by consent against Schaefer. And the writ date will be the writ date will be the 27th.
Correct.
And it's 291-632. Is it 32 or 30? Okay. So you're all set, and he's going to provide me with the writ date on the others, okay? I'm sorry, with the default judgment on the others. Sorry.
Okay, I was going to say, well, it's fine that those 2, I was going to say, didn't join the Zoom. That's fine, right? They'll just get the same.
Yeah, they're going to do the same thing.
Okay.
Okay.
I was just making sure. Okay, thank you.
Best of luck to you, ma'am. Thanks.
Thank you. Have a great day.
You too. Hamptons versus Clarice Lee, 2600355. And also Kyton Lyles and Christian Lyles Weems, 2600355. Clarice Lee, your name?
Clarice Lee.
Do you know where Kyton Lyles or Christian Lyles Weems are?
Both of those are my sons. It's okay for me to represent them.
All right, so they'll have to be a default. Did you resolve this with them?
We did,
With
Your
our-
Honor.
Give me the info, please.
So, Your Honor, we have a proposed consent judgment. Rent to retain in this case is $885.25. Court costs are $75 because, again, only the statutory attorney fee remains due. The grand total is $963.25 with the writ to issue after February 27th.
All right, so this will be, ma'am, since you're represented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. Do you agree to those terms you just outlined?
Yes.
So you understand you have until February 27th to pay. This will go, and that will be $963.25. And the other 2 defendants will be defaulted, same writ date, February 27th. Do you understand that?
I understand.
Pardon?
Yes, I understand.
And does Mr. Visconti have your permission to sign your name to a proposed consent judgment?
Yes.
All right, you're all set. Wish you well, ma'am. I think that's it for you, right, counsel?
That does it for me, Judge.
Thank you very much. Have a good day.
Wait, I didn't talk to anybody.
Miss
What's-
Parker, you're at 10 o'clock. We're getting ready to start yours. Just hang tight.
Ooh, okay.
Thanks, Judge. Have a good day.
You too. Thanks a lot. Geez, I got more. Marion Manor, I got more of these. Or what? Marion Manor
Yes.
versus Javon Crawley, 2600339. Is Javon Crawley here?
Good morning, Judge.
Where are you, Mr. Crawley? There you are. How are you?
I'm doing all right.
Your name?
Javon Crawley.
Wait a minute. I'm not getting you very well.
Javon Crawley.
Tell me your name again.
Javon Crawley.
Perfect. Stay there. Ms. Austin, your name?
Good morning, Your Honor. Rebecca Austin for plaintiff.
Did you talk to Mr. Crawley?
Did Your Honor waive a consent judgment?
Go ahead, please, with the terms.
Past due rent, Your Honor, $2,136.54. That includes $140 in late fees at $70 a month. Court costs of $176.54. So a judgment of $2,313.08. Mr. Crawley is going to pay $1,200 by February 19, and the balance of $1,113.08 by February 27. And he gave me permission to sign his name to that judgment, Your Honor.
Is that true, sir?
Yes.
So you agree that you owe that amount, 2313808, correct?
Correct.
Wait a minute, I'm not getting you. You got to get in closer.
Yeah, that's correct.
And you understand you have until the 19th to pay $1,200. If you pay that, the writ date will be extended until the 27th, at which time you have to pay the balance.
Yes, I understand.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yep, I understand.
All right. You are all set. I wish you well, Mr. Crawley. And again, she has your permission to sign your name to this proposed consent judgment. True?
Yes, that's correct.
You're all set. Thank you. Marion Manor versus Jasmine Parker, 2600341.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ms. Parker, your name?
Jasmine Parker.
All right. How many of these things do I have today?
Judge, we're winding down.
Good. Why don't you call those departments, tell them to get on there in 5 minutes. Go ahead. What do you have a consent?
Your Honor, Miss Parker is going to apply for rental assistance. So if we could get an adjourned date, please.
We're going to adjourn this to the 23rd at what time? 10?
10. Yes, Your Honor.
Ma'am, you're going to apply for funding. You have to provide us with proof within 5 days that you've submitted an application for funding. You have to bring that here. Okay, ma'am?
Okay.
And otherwise, and I'm going to adjourn this till the 23rd at 10. Any questions?
No questions.
I wish you well. Good luck. Marion Manor versus John Reagan and Alyssa Ochoa. It's 2600344.
Rebecca Austin for plaintiff, Your Honor.
Are they here? Mr. Reagan, your name? Mr. Reagan, you got to unmute. State your name, sir.
John Reagan.
Where's Alyssa Ochoa? Is she here?
She was not able to make it.
Okay, did you talk to Mr. Reagan?
I did, Your Honor. I have
Yes.
asked to Mr. Reagan and a default with the same terms as to Miss Ochoa.
Go ahead.
He has to rent, Your Honor, $1,286.41. That includes $170 late fee, court cost of $221.43 for a judgment of $1,507.84. Mr. Reagan is going to pay $500 by February 19, a balance of $1,007.84 by February 27, and he provided me permission to sign his name to that judgment, Your Honor.
Is all of that true, sir? Mr. Reagan, talk to me. Is that true?
I'm sorry, it keeps cutting out.
She tells me that you have a judgment amount of $1,507.84, that you guys agreed to that you gave her permission to sign your name, that you're going to pay $500 by the 19th with the balance by the 27th. Is that all true?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
All right, you're all set. Good luck.
All right, thank you.
Let me know when the departments are in. Marion Manor, and get Mr. Haynes versus Jayla Bullard, 2600345.
Rebecca Austin for plaintiff, Your Honor.
Name, ma'am?
Jayla Bullard.
Did you listen to and understand the rights?
Yes.
Is there a resolution, Ms. Austin?
Sure, we have a consent judgment for possession only.
Okay.
To retain is $885. That includes a $170 late fee, court costs of $176.54 for a total of $1,061.54. And Ms. Bullard is going to pay that by February 27, Your Honor. And she did provide me with permission to sign her name to the judgment.
Is that right, ma'am? You agree that you owe that amount? Did you give her permission to sign your name to this proposed consent judgment?
Yes and yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. Do you understand all that?
Yes.
Do you have any questions?
No.
You're all set. Good luck. Thank you. Gibraltar Point. Thanks, Ms. Austin. I think that's it for you.
I have a couple more, Your Honor. Tanglewood, but I'll wait.
All right. Gibraltar Point versus Harris, 2600348.
Good morning, Your Honor. Jen Wilburn, P83143 for plaintiff.
Good morning, Ms. Wilburn. Is Christina Harrison here?
She's not checked in with us, Your Honor.
All right. You can go ahead and take a default if you'd like.
I would, Your Honor. It is for possession only, no money judgment. I've got rent to retain, $4,622.17. I've got 4 late fees with the court's cap at $280. I've got insurance at $15 a month for a total of $60. That subtotal is $4,962.17. Court costs are $184.17. Grand total $5,146.34 to be paid by February 19th.
Writ date will be the 19th. Default judgment is entered. And 5,146.34 is the amount to be paid to save it. Gibraltar Point versus Banks, 2600349.
Jen Wilburn, P83143 for plaintiff.
Kenneth Banks here? Is Kenneth Banks here?
Judge, he did check in and we did speak. For the court's knowledge, he was planning to apply for rental assistance. I did go over that the DC 539 form would need to be submitted.
Turn it to the 23rd, defendant to apply for funding. I'll just indicate defendant here what left.
We'll do 8:30, Your Honor.
What's that?
The 8:30 a.m. that day?
February 23rd at 8:30 in the morning. Did you advise him? Does he know he has to apply? He has to bring his proof of application for funding up here?
I did, Judge, and I told him if he had any questions to reach out to the civil department.
Thank you very much. Is that it for you?
It is, Judge. Have a wonderful day.
You too. Thanks a lot.
Thank you.
Riverside Townhomes versus Andrea Martinez, 2600145. Ms. Martinez, your name?
Andrea Martinez.
Mr. Landau, your appearance?
Mark Landau on behalf of the plaintiff.
I'm looking at my notes. Rebecca A. Fry says she's I don't know. I can't read them. She's in the lease, not her daughter. On the lease, not her daughter.
Yeah, we've reached a consent agreement, Your Honor. Prepared to put that on record.
Okay. Well, who's Rebecca Fry? She's not a party here.
She's not a party. We've agreed to add her as a party defendant. She has signed off on an order, as has Ms. Martinez, adding her as a party defendant. And then upon entry of that, Ms. Martinez and Ms. Fry and I have agreed to the terms of a conditional dismissal, dismissing the case, allowing Ms. Fry to remain a tenant at the apartment complex as long as Ms. Martinez vacates. I can put the specific terms on record if you would like.
I'm not quite following this one. So you're saying that you're going to enter into conditional dismissal. You're adding Rebecca Fry as a party, and she can remain as a tenant in the property so long as Ms. Martinez vacates. True?
Correct. Yes.
How long does Ms. Martinez have to vacate?
She must vacate by February 26.
Ms. Martinez, do you consent to those terms?
Yeah.
And so you're saying Rebecca Fry can stay there now. Where is Rebecca Fry? This would have been easier if she showed up. Why isn't she here?
She is. I'm right here, Your Honor.
All right. Rebecca Fry, your name?
Rebecca A. Fry.
So do you understand that you're entering into a conditional dismissal and that the case will be dismissed subject to certain conditions being met? You can stay as a tenant. They're adding you as a party defendant, but Ms. Martinez has to vacate by the 27th. Do you understand that, or 26th is it?
Yes.
Mr. Landau, is it the 26th or 7th?
It's the 26th.
So do you agree to those terms, Ms. Martinez?
Yes.
Do you agree to those terms, Ms. Fry?
Yes.
Do you fully understand everything? Since you're unrepresented by a lawyer, both of you have 3 business days to come in here and fill out a motion to set aside the judgment. Do you understand that, Ms. Martinez?
Yes, I do.
Ms. Fry?
Yes.
Yes?
Yes.
Does Mr. Landau have your permission to sign your name to this proposed conditional dismissal, Ms. Martinez?
Judge, they've already signed and returned the conditional dismissal to me.
Good enough. All right. So you're going to submit all that paperwork today, right?
I will. Just to make it clear to the court, there's a separate order, stipulated order to add Ms. Fry as a party defendant.
So send that first. Can you, if you haven't sent these, send that one right now. And then Jennifer, make sure I get them at least simultaneously, will you? I don't want to be signing the conditional dismissal before I've signed the order permitting Ms. Fry to be a party. Okay.
I'm going to send it as one packet, Judge. One other thing, Ms. Martinez and Ms. Fry signed the conditional dismissal separately. So I'm actually going to be sending the same CD twice. Once with Ms. Fry's signature, once with Ms. Martinez's signature.
Good enough. No problem.
It's all going to be in the same packet, though. 3 documents.
Thank you. I wish you guys well. Thank you very much. Have a great day.
Thank you.
Thank you,
Tanglewood versus Angel Justice. 2600347. Who has Tanglewood today?
I do, Your Honor. Rebecca Austin for plaintiff.
Is Angel Justice here? There you are. Start your video, state your name, Angel Justice or Angel Justice. I'm sorry if I'm mispronouncing it.
Angel Justice.
You got to start your video, ma'am. Is this a consent counsel?
It is, Your Honor.
Give me the terms, please.
Past due rent, Your Honor, $1,022.16. That includes $170 late fee. Court cost of $176.54 for a judgment of $1,198.70. Ms. Justice is going to pay that by February 27th and provided me permission to sign her name to that document.
Em, do you agree that you owe that amount?
Yes.
And do you understand that you have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment? Also, you have 10 days to appeal. And otherwise, you have to pay this. Do you understand? By the 27th of February, you're vacated. If you don't do either one of those things, you'll be evicted. Do you understand that?
Yes.
Any questions?
No.
All right. If you got to come to court again, make sure you can log on to Zoom, okay? In the
Okay, I'm
future. Good luck.
sorry.
That's all right. Best of luck. Tanglewood versus Brittany Austin White, 2600350.
Rebecca Austin for plaintiff, Your Honor.
Yes.
Your name, ma'am?
Brittany Austin White.
All right. Any resolution here?
Miss Austin White is going to apply for rental assistance, Your Honor.
Ma'am, did you listen to and understand the rights?
Yes.
And do you wish to speak to a lawyer?
Yes.
All right. So we're going to give you they'll chat with you. They'll give you the number. You have to, if you're going to apply for funding, you have to provide us with proof of that within 5 days.
Okay.
I'm going to adjourn this until the 23rd at 8:30, Jennifer?
10 o'clock. 10 o'clock.
10 o'clock. All right, 10 o'clock. But you have to provide us with proof that you made that application for funding within 5 days, okay?
Okay.
Good luck. Thank you.
Thank you.
Tanglewood versus Patria. Coleman? 2600351. Come on up here, ma'am. Did you state your name? Did you listen to and understand the rights?
Yes.
Ms. Austin, your name?
Rebecca Austin for plaintiff, Your Honor.
Did you speak to her?
I did not, Your Honor. I didn't realize she was even there.
Judge, they just put her on a tablet to show her the video. We didn't realize she was in the courtroom. So she has
All right.
watched the video, but never got to speak with Miss Austin.
All right. What do you want to do? You want me to have her talk to you now?
Or, it's a small balance, Your Honor. If I can provide you with that information and perhaps we can just.
Go ahead.
Past due rent, $887.54. That includes $170 late fee, court cost of $176.54, totals $1,065.08. She just really owes February rent and late fee at this point, Your Honor.
Ma'am, do you agree that you owe that amount?
What's the amount?
$1,065.08. That includes your court costs, your late fees, and your February rent. Can you pay that by the 19th?
Not by 19.
When can you pay it?
Probably
I can't hear you, ma'am.
by the 30th.
There is no 30th of February. Can you pay by the 28th?
Yeah, I can.
Any problem with that?
None at all, Your Honor.
All right, so well, actually, can you pay by the 27th? The 28th is a weekend. All right, so do you wish to enter into a consent judgment with her whereby she's, and if you want, you can give her permission to sign your name for a total of $1,065.08 with a writ date of February 27th. You agree to that?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
What does the set aside motion mean?
If you don't understand something here, since you don't have a lawyer, you could come in here and fill out a motion to set aside the judgment. Judge, I didn't understand it. Have I covered it with you good enough? You understand everything? All right, you're all set.
Magistrates earlier.
I guess before we begin, Mrs. Enda.
Start. What's your name? What's your name?
Do that. I never started from that side. Ms. Enda.
Good afternoon, Your Honor. Alexander, on behalf of the people, Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
All right, Mr. Brown.
Your Honor, we waive any such conflict when it exists. We don't.
And the court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus VJ Dandamoody. Hold on, Mr. Hauser.
Good afternoon, Your Honor.
Alexander, on behalf of the people.
Attorney Matt Hauser here on behalf of Mr. Dan Damoody.
Sir, can you state your name, please?
BJ Moody, Your Honor.
All right.
Chris Clare on behalf of probation. Your Honor, Mr. Dandamuni is before the court for a violation of probation hearing. The court, Mr. Dandamuni was recently before you, and this court had set the violation hearing out. I asked this court to set it for today. I did have a chance to speak with the victim in this case. The violations are still the same, Your Honor. It's a violation of the no contact order with the victim in this case, with the numerous emails that were sent, and the new criminal convictions with the both felony cases. This court was made aware at the last hearing of what that sentence agreement was for Mr. Dandamuni once he goes to court there. He already was sentenced on one of the cases to 6 months in jail, followed by 5 years of probation. On the other case, the conditions of that sentence or plea agreement to that is that he be released from custody on a GPS tether to inpatient mental health treatment, then on home confinement at his parents' house. Once that's completed, that's part of the felony case. Your Honor, I did have a chance to speak with Ms. Hodge and went over with her, so she clearly understood what took place with the felony plea and agreement. Given all circumstances, probation has amended the recommendation in this case. I don't normally do that when there's a clear conviction or violations. However, in the best interest of the victim and the defendant in circumstances that has happened to date, probation is now recommending that the court sentence Mr. Dandamuni to 152 days in jail with credit for 152 days served for his violations to date, that he continue probation in this matter with the added conditions: 1, to be released from custody on a GPS tether; 2, inpatient mental health treatment. Once inpatient mental health is completed, he's to be placed on home confinement at his parents' residence. That is in Battle Creek. And that should there be any outside necessary appointments, that Mr. Dandamuni remain within Calhoun, Kalamazoo, Berry, and Eaton counties. Also, that the court impose no use of internet for any reason except for documented medical appointments, with a scheduled review hearing being set April 20th, 2026 at 1 p.m.
Mr. Hauser, anything you have to say regarding that?
No, yes, that is an accurate representation of the conversations that have occurred over the course of the last week. I guess the only update I would have is just as it relates to the jail credit, were we going to sentence less than what his current credit was? Because last week I believe it was 204. I was wondering where that 152 had come from.
Your Honor, I didn't count the prior jail time from the first violation. I just counted from his time and this time.
Yeah, okay, I see.
Does that make sense?
Yes, it does. Okay. It does. That because that's this sentence for this violation.
Correct.
Right.
Okay. And then the only other item was, as was mentioned last week, there was the appointment at the Mayo Clinic coming up on the 26th. So there was that request for travel outside of the state. I believe the dates I received from Dr. Dandamuni, VJ's father, was February 14th through the 17th, and that would be travel from Michigan to Minnesota. Of course, all other conditions would apply.
And Your Honor, I would like it being clarified to the court and to probation about the inpatient mental health facility. The documentation that I show that this is taking place in Battle Creek. Is that right, Mr. Hauser?
Yes. Yep. It is. It is Pasadena Villa in Battle Creek, and I'm actually to follow up with Sabrina, the coordinator from there, after court today, based off of what is determined. And what I can do is I can also CC probation as well in any further communications with Sabrina, so that way all parties are on the same page.
So you're asking for permission for him to travel to Minnesota?
Yes, he has an appointment on February 16th at the Mayo Clinic in Minneapolis.
Okay, and when would he then return?
On the 17th of February.
On the 17th. So it's basically a 1 day.
Your Honor, the documentation that he sent to me, the flights would be leaving on February 14th and returning on February 17th.
Is that correct, counsel?
Yes. Yep. The email I received from Dr. Danamuni was, yes, the flights would leave from Grand Rapids on February 14th in the afternoon, and then return the 17th in the morning. So it would be for a few days.
So the appointment on the 16th is documented, and basically the evening of the 14th, 15th is basically travel to that appointment. Okay, I'm not going to have any problem with that.
Okay, Your Honor. So probation could notify community corrections of this being, okay.
That this is approved. All right. Anything else from the people at all? Or?
No, Your Honor.
All right. The court will sentence the defendant to 152 days in jail, credit 152 days served for his violations to date. The probation will continue with the added conditions that defendant to be released on a GPS tether to inpatient mental health treatment. Once inpatient mental health is completed, he's placed on home confinement at his parents' house at their residence in Battle Creek. Defendant to remain in the counties of Calhoun, Kalamazoo, Berry, and Eaton with respect to any outside necessary appointments, with the exception of the Mayo Clinic in Minnesota that the court has just approved. There's to be no use of any internet except for documented medical visits. You understand that, Mr. Danbury?
Yes, sir, Your Honor.
All right. I'll set a review hearing in this matter April 20th, 2026, 1 p.m.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Roberto Evans.
And then on behalf of the people.
I'm appearing on behalf of Mr. Evans. He's in custody, Your Honor.
Oh, we have to wait.
Oh, he's on Zoom?
Do I have an out of custody? No, I don't, because it's not. Okay. Roberto Evans.
Stay right here.
Hey, Your Honor.
Oh.
You want to state your name?
Roberto Evans.
All right. What are we doing?
We're here for a pretrial, Your Honor. I also received this morning a domestic violence bond violation report.
From Bedfield?
Yes, Your Honor, dated January 30th.
Yes.
Your Honor, I've shared it with my client. He understands he has a right to a hearing. He's willing to admit that he violated condition number 9 in that he had contact with Quietra Bryant, Your Honor. He went over there to obtain his mail. He pays the bills over there. So he went over there to get his mail to pay his bills. She's on the lease and he's on the lease.
Yeah, but he understands he's not supposed to be there.
Yes.
Then that makes no sense to go over there and get your mail without.
Well, he's got to pay the bills.
Well, he could have arranged for a civil standby to go get his mail if that's what he wanted to do.
I know that now. That's what I would do for.
No, you knew it before because it was given as a condition of your bond.
And Your Honor, I also have concerns that he moved a .323 VAC when he was picked up for the stop violation as well.
What was it?
.323.
Yes, Your Honor.
All right, so what are we doing on this case?
Your Honor, I'm requesting an adjournment.
I'll adjourn the matter to
March 2nd.
You don't have any dates for in custody sooner?
That's the next, March 2nd, 2026, 9 a.m. Part of this, but the bond violation in and of itself didn't reference the alcohol use.
Nope.
I don't think.
No, I didn't see it.
Your Honor, on the
Well, it does, I see. Yeah.
Well, it does and it doesn't.
What do you mean?
I mean, on the second page, it says, no use of alcohol, no contact with Quit Bryant, do not go to 2152 Glencoe Hills. And the officer had reasonable cause that the defendant violated those conditions. So I didn't have the amount of alcohol that was in his body. I just had in the cover sheet, complaint of violation, conditional release signed by the investigating officer. Says no use of alcohol, didn't have the amount. For the level.
We now know is a 323. So,
Your Honor, he's employed. He just got a raise and he was promoted to manager across the street at the Kentucky Fried Chicken on Washington.
yeah, but the problem is he can't go. There's a lot of alcohol. That's number one. And then he's going there in violation of his bond conditions. I'm not sure how we keep him.
Your Honor, he has an alternate address where he can reside with his sister. And if the court were to put him on a tether.
But a tether doesn't help us.
GPS would.
Well, it really doesn't help us because he went someplace he wasn't supposed to go. Regardless of what his reasons are, he wasn't supposed to go there. And he had a mechanism by which he could have gone there to get his mail. He chose not to do that. And then chose to just drink a boatload of alcohol. I guess that's not a quantifiable amount, but.
May I say something, Your Honor? I didn't.
At your own peril, go ahead.
I did not go inside the place. I did go there, but I did not go inside the place. And I was outside of the place. I knew I couldn't go in, and I didn't. And even when the officer showed up, I was not even at the place. I wasn't even nowhere near the place. I went there for a reason and I left.
I think the report indicates also that the complaining witness did not know that he wasn't supposed to be there.
Whether she knew, he knows.
I've explained that to him, but bills were due, Your Honor. It's the end of the month.
And kids to stay there, and I had to just make sure everything was intact because we got 6.
He could have done all of that with a civil standby. That was explained at his arraignment. He could have done everything that he had a concern about with a civil standby. But instead, what he's chosen to do is to go out there and drink and then just go over there and then try to split hairs with me. Well, I didn't go inside and I thought I could be there. He knows he can't be there.
He's dealing with the practicality of having to pay bills. That's all, Your Honor. The lights, the heat, the rent.
Send cash. I don't know what you want me to tell you to do. The problem is he can't be there.
I will not go back there, Your Honor.
At this point, his bond will continue as revoked. We'll see him on the second.
Thank you.
That gentleman was raising his hand about right there.
There's our camera.
Court calls the case People versus Kent Robinson.
Alexander on behalf of the people.
Rob appearing on behalf of Kent Robinson. Introduce yourself.
Robinson. Thank you.
I'm requesting a 2-week adjournment if possible. He's in custody. He has a PCC on Thursday.
This Thursday.
Yes, Your Honor.
Well, my next available date's the second, so that's about where we are. It's a little bit longer than that, but
Your Honor,
yes.
if you take any action on his bond, reducing it on Thursday, may we join in that motion? On this case, I think he has a nominal bond in this case.
He's what?
He has a nominal bond in this case, so that he's garnering credit while he awaits disposition of the felony.
Right, he's got $100 bond basically on this case.
Yes, Your Honor.
And on the felony, if I were to reduce it, certainly I would take a look, but I don't know. I don't have that in front of me.
Just for the court's reference, on at least the felony I have on text show that his bond is denied, because I believe we picked this up while on.
Got it. So that's probably unlikely to occur.
I got to ask, he asked me to ask today.
Turn this matter to March 2nd, 2026.
That's the earliest.
1 p.m.
Got $100 bond on this case.
It's 1 week out from what you requested.
Thank you.
Thank you. Is that it? All right. What?
Till 1 o'clock.
Till 1 o'clock. All right. I'm actually ahead. I'm impressed by me. 14A stands in recess. All right.
Device as a condition of bond. Darian Patterson, Mr. Burbank. Is Darian Patterson here? That's you, sir? Where'd he go? All right, stand by. Paul Smith, John West. Yeah. Yeah.
Your Honor, I was state let me know this morning that Mr. Smith has a new case that's just been indicted I think it's a week or so. And so we just want time to figure out how to handle both things. Is that there maybe?
Okay, let's see. What we've got here is theft of service, state jail felony. What's new?
Your Honor, he was indicted on a new possession of a controlled substance case. Possession of a controlled substance case. So Mr. West is asking if he can have some time to work them out
Give
together.
me the indictment, or can you give me any information about this? Thank you.
Here's the indictment on that case.
I need to go over this case so that Mark, he knows about that. It's a different day, a different time. Still gonna help us negotiations.
So, yeah,
Hey, guys, so the deal is, okay.
No, I'm doing you're doing don't make it back. I didn't find it in the email that they.
Good.
I don't want to make the case, but
At 20. Okay, now I see what's happening. So he's indicted May of 24 for an offense that allegedly occurred January 27th, 2024. State jail felony of theft. Then apparently he's not arrested for a while.
I think that's true now.
Until he gets arrested for the state jail felony of methamphetamine, which occurs on February 12th, 2025 is the allegation of the offense. And that's when he is in, that's the day he finds himself in custody. And he's before a judge the next day on 2/13/25, a year ago. And he's given a $6,000 bond for the theft and $10,000 for the possession of drugs. And you also have a drug patch as a condition upon?
No, sir.
You do. I just ordered it. You're going to have a drug patch. You got 24 hours to get one, 48 hours to get one. But why that wasn't done is beyond me. It's done in every drug case, especially methamphetamine. I don't know what the JP was thinking about. It's not a debate.
I should. I'm not. I was.
And the drug, it's a patch. You check it, shows up positive, you'll sit in jail until we can get this done.
Yeah, I see this.
Reset. No more resets. What are we doing today?
Well, Your Honor, like I said, I was wanting the time to go over this new case to figure out what's going on. And
what new case is it?
The drug case just got indicted.
We're set for trial on the theft of service, Your Honor. The new case, I provided an offer to Mr. West to work them both out together. He just hasn't had an opportunity to review discovery.
Yeah, but he was.
The state's ready on the theft of service if we need to.
A year ago, he knew that was, y'all knew that was coming down the pipe. Yes, Judge DeRuin went methodically and slowly, and he had to post 2 bonds. Well, you had to know that. But, all right, that's it.
Thank you.
Is this for me? Or
that's my copy. I just let you review it. I can print you one.
Oh, nice.
The 26 0129. It might not be. It was in the just a record.
Yeah, it's just. That's me. No.
You want me to try to find it for you?
No, the indictment's good enough.
That's really all there is. Yes.
Today, what are you doing today?
I'd ask for a reset on this.
Why don't y'all go over this before you ask for the resetting?
Let's go over the discovery and show my client this new case. So we can we can even take a short reset if you want to give us some time so I can go and discover my client. Yeah, that's fine.
Okay. 2. Okay.
Reset from her and meeting outside.
Reset 2 weeks.
Reset from her.
Thank you.
To give you one available.
Yeah, let's see. Mark Greenberg. Mark Greenberg.
My client has the flu. He contacted me this morning. And I'm getting a medical proof of that. Additionally, I filed a motion for continuance on this case. This is a new case to the prosecuting.
Yeah, but it's going, it'll be 2 years old in a few months.
Your Honor, if we need to, we can get ready, but Mr. Smith did file a motion for continuance last
What
week.
was interesting, Judge, what's interesting about this case is that the prior attorney, prior PA, was going to reduce this to a JP. Then new DAT.
Well, y'all didn't.
Actually, that was mine, Your Honor, and I was upset.
I'm sorry?
That was actually my case before.
Hold on, so one at a
But,
time.
I mean, once I got it, I gave it to, it went from me to Kyle after me, and I'd spoken with the.
I can imagine I wanted to try this.
Hold on. Go
I
complete
spoke
the
with the
thought.
complainant, he very much, wants to go forward with it, not as a.
Well, that's fine.
Yeah, I'm just saying once I had it, and Sonny may have did something different, but I had it and then it went to Kyle. And when I've spoken with the complainant, he very much, so it
Well,
goes.
there's body cams and eyewitnesses and all of that.
No. We're not going to try it this moment.
Yes, Your Honor.
So.
We have tried to work this out. I don't think it's going to be worked out.
Okay. That's why God invented trials. I guess he did that because it was a wise thing to do. Okay. And this is
in that event, then I would suggest it.
Well, sorry. Fake news.
Yeah, I agree.
Okay. So today.
Governor, he has the flu. I filed a motion for continuance. He told me that he can get the medical doctor approved.
3 weeks. Reset 3 weeks. Okay. Quinn Swafford. Langston. Quinn Swafford.
Judge ready, Judge.
Great.
And Jacob Houston.
Where's this one?
Brandon LaFleur. Come on.
Judge Houston.
Is that it? Okay. Brandon LaFleur. Jansen.
Step over the machine. Talked to Mr. Bailey this morning, Judge, and
what are we doing on that?
He's apparently gotten into this case recently, and I just released discovery to him today.
Oh,
so this needs to be reset.
You're Brandon LaFleur?
Yes, young. Right.
We gotta wait for Mr. Bailey to make a, just have a seat. And when he gets up here, we'll see what he wants to do today. And Koenig, Brian Lane?
Yes, sir.
What are we doing? Or Arnie? It's Arnie. Koenig. Is that right? Arnie Koenig?
Arnie Koenig, yes, sir.
What are you doing?
We're asking for continuance. We're waiting for the Beaumont Police Department to send over a phone dump and a search warrant, which they did not supply us to the prosecutor's office.
It was not given to us with the case.
It's a discovery.
We will have to reach back out to the police department to get that information.
Okay, how much time?
30 days.
Okay, reset 4 weeks.
Thank you.
4 weeks, and then just have a seat right in here, sir, right up there. Probation. And Ricky Turner. John? Mhm. Ricky Turner.
Right there.
Come on.
Ready on, you can ready on some.
That's trial.
Yeah.
Okay.
You're good.
All right. Kimler, Mr. Kimler, come on up. You got a disposition? Thanks. What's his name? This is Mr. Houston.
This guy.
Cases for pleading the one, she's dismissing one, he's got 10,860 out of institution. Is that right? That's an 860.
Yes, I believe so.
Okay, we got 2 cases. He's going to plead to one and one's going to be dismissed.
Oh, one, oh, two is getting dismissed.
That's correct, Your Honor.
Someone trial.
All right, we talked 2 cases, 24 CR 1901, 1902, the state of Texas versus Jacob J, middle initial, Houston. That's you with Mr. Kimler, your attorney and the state's attorney. On 1901, does the defendant waive a formal reading of the indictment and arraignment here? So we proceed in separate. In summary, this indictment alleges that on or about August 17th, 2020, and continuing until on or about December 28th, 2020, in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you're charged with?
Speaker?
Yes.
Okay. Yeah. Just straight up. Perfect.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. And also a fine up to $10,000 can be assessed. Do you understand? An agreement has been reached in your case. You'll be pleading guilty and placed on deferred or unadjudicated probation. This can be up to 5 years in length. There will be terms and conditions of probation, which are normal and customary. The most important thing, there's restitution owed in the amount of $10,869. I think I can't read that last number. Is that even, or is there 8 cents or something?
There's no sense.
No sense. Generally, there's never been cents up here. That was kind of a side remark. Yeah. How are you going to pay this back, sir? A little at a time, I guess.
Yes.
How much are you able to pay back per month? Because that's really the key thing. Once you get it paid back, as long as you're doing fine, I dismiss these cases. I dismiss it. It's dismissed as long as you don't have any other problems. But it needs to get paid back. That's how you fix it. And the quicker you pay back, the quicker the damages. $500 a month. Can you? All right. Well, that's 20 months.
COVID benefits that he wants to pay time to me, I think total payments made and they started there should be sustained.
Yes, it goes to the Texas.
They don't
Work
forget you,
Commission.
and that they make something will be taken away from you, by governments when you don't pay if you owe them somehow. The way they do that. So you want to get that done so you can move on with your life. Is that your understanding of the agreement, as well as a second case will be dismissed? So if I follow this agreement in each case, you have no right of appeal. Do you understand?
Yes.
How do you plead to this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney or the contents true and correct? State's Exhibit 110, without objection, admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily made you know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer? All of this is true. States at the bottom, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
So waived.
If nothing further, I will find as follows. You are mentally competent, sir, Mr. Houston, to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt from States Exhibit 1. But I'm instead going to defer and postpone any finding of guilt so long as you follow the terms and conditions of probation, which I have before me. This will be for 5 years and will be shortened if you do well. There will be various terms and conditions of probation, which are normal and customary for this type of offense. Most importantly, restitution is owed to the complainant in the amount of $10,869. It looks like Texas Court Enforcement Commission or the state entity that runs and manages that entity. And that is, as long as you do well otherwise, that's really the thing that's keeping you on probation. And then do well, probation is dismissed. And the case is dismissed without a conviction. Can't be that.
Judge, we'll add a theft prevention program as well.
Yeah, that's normal and customary for everything for that type of offense.
Yeah, I need to print it.
Please, probation. What to do, so thank you. I have from Mr. Houston, there's a dismissal, cause number 24 CR 1902. That is signed now. That case is hereby dismissed as part of this agreement. Here's Houston's.
Yeah, right here.
Yeah, that's about.
Here's Houston's files. Thank you.
Here today.
Yeah, I'm gonna be.
All right, I've got, we took care of Bruce Calhoun already, didn't we?
No, that's.
Come on up. Come on up.
Trial back.
Yeah, come on up. And Willie Pugh, we did Mr. Pugh.
No, sir.
No, we have-
That's yours, isn't it? Oh,
So the lawyers.
Christian Simeon, have we done Christian Simeon's as well?
Not yet, no.
Okay. Langston, your man,
Yes, sir.
Bruce Calhoun?
He's
Is he
signed
you?
the paperwork. He signed everything.
Where's? 3CR 159 is now called State of Texas versus Bruce Calhoun. It's just one case, right?
Yes, Judge.
Yes, sir.
You're Mr. Calhoun. Does the defendant waive a formal reading of this indictment and arraignment in 23C0159? And we proceed in summary.
Yes, sir.
In summary, Mr. Calhoun, this